This hearing is in the matter of case number CFI 15-2019 before Justice Sir Jeremy Cooke. The claimant is represented by Mahmoud Hussain Law Firm, and the lead counsel is Michael Patchett Joyce. The defendant is represented by HFW, and the lead counsel is Stephen Doherty. Thank you very much.
Very good. All right. Mr. Aloub, you're still under oath, you understand?
Yes, I do.
Thank you very much. And Mr. Patchett Joyce will have some more questions for you.
Okay.
Good morning, Mr. Aloub. Could we start where we left off at page 845?
Okay, just 1 second. That's page number 845.
Yes.
Okay, that's the Sudatel contract.
Yes. And
Yes.
are you able to go page by page quite quickly, Mr. Aloub, so that we can see the entirety of this contract by looking on quickly at pages 846, 847 and 848,
Yes.
which is the entirety of the contract, both in English and in Arabic, yes?
Yes, yeah.
And then at page 849, we have a table with figures in, which is again in Arabic. And then over the page to 850, we have the concluding page.
Yes.
And that page is then, I think, translated on page 851, yes?
851.
You have 851 in front of you?
Yes.
And here we can see that Mr. MUSAAB signed, describing his position as Director of Planning Department, EXPRESSO HQ, isn't he?
Yes.
And we established that that was the corporate headquarters registered in the DIFC yesterday, yes?
Yes.
And what I would therefore put to you is that when we're looking at this document, it's quite plainly an addendum to the work, an addition, let me not use the word addendum, an addition to the work that he was doing for EXPRESSO back in the DIFC, isn't it?
Well, to be honest, I cannot entirely agree with your statement, because we didn't come to know about this agreement or the fact that he was receiving salaries in Sudan until after there was some sort of a dispute about his entitlement and what we should include and what we shouldn't include. Then when I contacted Sudatel HR, they came up with this, and this was a surprise. I didn't know about this.
But Mr. Aloub, Sudatel is the 100% shareholder, entire owner of EXPRESSO Telecom, isn't it?
I agree.
And therefore what was happening was Mr. MUSAAB had been asked, maybe not by you, maybe by the CEO, but had been asked to work and assist in Sudan. And indeed, we've been over his job description. He was working across the countries in Africa where EXPRESSO Telecom was conducting its business. That's the situation, isn't it?
That I am not objecting to. The only thing I'm objecting to is that the way he described his entitlements and his failure to mention that he signed a contract in Sudan and he received amounts of money. Until we brought this forward on emails exchanged with MUSAAB, until then he said, okay, fine, and he agreed to us deducting these amounts from the final settlement at that time during the discussion phase.
Mr. Aloub, we're going to come on to the money in due course, but what I'm putting to you, it may be that what you're telling the court is the limit of your personal knowledge, but you were not the CEO. We are not hearing from the CEO. And we heard from Mr. MUSAAB yesterday that he was asked to relocate, and he needed to do that pursuant to clause 1.2 of the agreement of 2008, the contract of employment. That's the situation, isn't it, Mr. Alou?
I believe so.
Thank you. Now let's move on to page 852, because what we have at page 852 is the translation of the table that we had seen and passed over because it was in Arabic back on page 849. That's correct, isn't it, Mr. Alou?
Yes. Yeah.
So what we can see is that it's a table, as is the nature of the table, with a number of rows and a number of columns. The first column is a narrative of what the amounts are in the remaining columns, yes?
Yes.
And then what we have, as I understand it, is a number of items, all in Sudanese pounds, attributable to the first column, with periodic totals added in the second column. So, for example, the 6,473 in the second column is the sum of 5,923 and 550 above that figure, but in the first column, yes?
Yes.
So if we concentrate on the second column, what we have is total monthly payments and total monthly deductions. Payments of 6,473 Sudanese pounds and deductions of 1,560, and we can see how those deductions are made up in column 1, yes?
Yes.
So that what we can see in column 3, all column 3 is the annual total. So it's the two figures that we've just identified in column 2 multiplied by 12, yes?
Yes.
And then there are, well, let's focus on the monthly figures because that's quite straightforward. This is in Sudanese pounds, and you'll recall that the court asked yesterday for a currency conversion into dollars. Now, I don't think that that's been agreed yet, but what I'm going to do is read into the record the sums in question on the 1st of September 2009 as derived from an independent historic currency conversion website. Yes?
Yes.
So that on the 1st of September 2009, $1 was the equivalent of about 2.43. I've rounded it, or I've taken all of the long decimal pointages off and rounded it to the nearest cent, or whatever the subdivision of a Sudanese pound is. $1, $1 was the equivalent of 2.43 Sudanese pounds on the 1st of September, and therefore 1 Sudanese pound was the same as 41 cents in dollars. So far as the dirham figure is concerned, should anyone wish it, 1 Sudanese pound on the same date was the equivalent of 1.51 dirham, so that 1 dirham was the equivalent of 0.66 Sudanese pounds. Yes? Now, assume that those figures are correct. If we look at the value of the total income 6,473 Sudanese pounds,
Yes.
would you accept it from me that that equates to $2,665.25?
I believe I will take your word for it.
Okay. Yes, we can check this. I'm sure it can be checked. And if I've got any arithmetic wrong, I will be more than happy to stand corrected. But I've done the same exercise with regard to the 1,560 deductions. And in the dollar value of that on the same date was $642.33.
Okay.
So if one deducts, in order to get the net pay, you take off the deductions from the monthly provision. So we're deducting 1,560 from 6,473, and that, as a matter of arithmetic, gives 4,913. And 4,913 Sudanese pounds is the equivalent of $2,022.92.
Okay.
Against that, if we remind ourselves, you can look at it if you need to, but I think it's a matter which we don't need to look back on. On page 794, the remuneration, you do look at it if you wish to, 794.
Okay. Yep.
The remuneration that Mr. MUSAAB was receiving under his contract, or should have received under his contract in Dubai, was a monthly gross salary of 40,592 dirham. Yes?
Yes.
And converting the dirham to what we've fixed upon as the common currency for present purposes, 40,592 dirham equates to $11,053. And of course, there's no personal income tax in Dubai, is there?
Yeah.
So therefore, if one is looking at the take-home figure, the take-home figure under his Dubai contract was over $11,000 per month. And what he was deriving under this arrangement in Sudan was a little over $2,000 a month, wasn't it?
Well, to be honest, as long as he was unable to relocate or to locate to Dubai at the time, and he remained or he accepted the move to Khartoum, I think it's only fair that he's getting paid according to the pay scale of Sudatel at the time. That's the way I look at it. However, there is other components I'm sure that we are not aware of, because I know all the executive management team, for example, in Sudan, they receive other privileges that are not necessarily included in the contract.
And there is no evidence in that regard at all, is there, Mr. Aloob? Let's compare like with like on the material we have. What is that the arrangements in Sudan were less than 1/5 of his contract salary.
Well, I think to be fair, Mr. Patrick Joyce, you have to take into account the annual provisions as well. If you're making a comparison, you would need to look at the third element of annual provisions and then subdivide those to get a monthly figure if you're going to do an exact comparison.
Even taking that point, Your Honour, one would be adding, I haven't done that sum.
Well, it's about another 3,000, isn't it? Divide 35. No,
No, it's about 1,200, 1,300.
Well, it's 35538 divided by 12, isn't it?
It's yes, and then converted
and then
to
converted,
dollars.
and then converted, exactly so.
Yes, and I mean, I'm very happy to do that sum now if you'd like me to do
We get the broad impression.
Unobliged. Even adding the total annual provisions or benefits, it only adds about $1,300 per year. Sorry, no. I will do the sum because I'm getting my months and years confused. I will do the sum properly rather than think on the hoof.
It's a small figure compared with the overall figure he's being paid in Dubai. That's the point you're making. And
that is the point.
That's the point you want Mr. Aloob to deal with.
Exactly.
Yeah.
So even,
but again, if I can add, I think for anyone who moves back to his home country, because when he was hired as a Sudanese. We did not consider the UK citizenship until later on, when he insisted of being treated as a UK citizen. But at the beginning, he was a Sudanese. For any Sudanese who's living in Sudan, receiving a salary, even if amounts to $2,000 or even $1,000 at that time in Sudan, in US dollar, and I think having a house or a residence, you don't have to pay rent, and you don't have a huge family. I mean, at that time, I believe he was single. He was with his family, with his parents. I'm sure that will be sufficient for him, according to the Telpay scale.
Mr. Aloob, we are looking at what, on your case, Mr. MUSAAB was giving up. To be totally fair to you, one might add in the 12,500, which you say was by way of consultancy, but which Mr. MUSAAB fully acknowledges he was paid as part of his salary in Dubai. Now,
that's the whole idea. The 12,500 was intended as some sort of compensation in case of having opened the bank account in Dubai, or having credit limits in Dubai that you need to pay back, because this was not applied to MUSAAB alone. There were 3 gentlemen who endured the same thing. And I use the term endured because honestly, this was Sudatel decision, not mine or the decision of EXPRESSO management. There were 3 of them: Mr. Nazar, Mr. Muhammad Sharif, and MUSAAB. For Nazar and Muhammad Sharif, they accepted the consultancy, they signed, and they received that amounts. For MUSAAB, he received the amount, but he refused to sign.
Mr. MUSAAB refused to sign for the reasons he gave in evidence yesterday. Let's just remind ourselves of what he said. He fairly acknowledged that he agreed there had been a restructuring. He agreed that the defendant, your company, had proposed a new arrangement. He said he didn't mind discussing that arrangement, but he was on a contract for fixed term at 40,000 or just over 40,000 dirham a year. And he said in evidence yesterday that if there was to be a change, that had to be accepted by both parties in writing. And that is part of the provisions of the first, and indeed all agreements, that are before the court. We can look at it if you wish to, but any change to that agreement had to be in writing, didn't it?
Absolutely, I agree with what you're saying, but I have to also bring your attention to the fact that Mr. Imad Hussein, the CEO of EXPRESSO Group, that you see his signature was more like overriding anything that we agreed upon. So if MUSAAB and Mr. Imad Hassan agreed to some sort of an agreement in Sudan, we never became aware of it. And his objection to the content or the extent of that agreement never became known to us until it was time to settle his final dues.
So
then
it
at
is,
that time he said,
So as far as I understand your evidence, Mr. Aloob, the evidence that Mr. MUSAAB gave of having spoken to senior people within EXPRESSO, and in particular the CEO, is something that you perfectly accept may well have taken place. And he says he brought all of this to the attention of EXPRESSO. We're not hearing from the CEO, and the court has to make the best of the material before it. That's the position, isn't it, Mr. Aloob?
Honestly, I cannot agree fully, because I know for a fact that MUSAAB enjoyed a very unique status in the group, and definitely he was a member of the executive management, and not like what he's trying to make it appear as if he's a weaker link. He wasn't a weaker link. He was a member of the executive management team, traveling with group executive president. And for that reason, I cannot accept the fact that he was unable to bring the claim forward in writing, or at least to have some sort of document to make us aware of the fact that he is not accepting, or to the extent that he can actually refuse
He doesn't
to accept
need
the 12,500.
He doesn't need a document, Mr. Aloob, beyond the employment contract, which he has and which he was drawing to people's attention. That's the situation, Mr. Aloob, isn't it?
Well, unfortunately, it is not, because if we're going to talk about the employment agreement, my understanding is that it was signed by the group. We never came to know about it. Then he never actually participated. How can I say? For example, there is no attendance sheets for him among the team in EXPRESSO. There is no annual leave recording. My understanding that every year the entitlements of each employee, including myself, will be verified by our finance team. Numerous times, I'm sure he received the emails, but I can see how selective he is. Sometimes he says, I received the email, I didn't receive the email. And that's why, and look, and it is dragged for too long, and I wish to see an end to it, but trying to make him look like a victim, he's not a victim.
Mr. Aloob, the position is very simple. If you, EXPRESSO, wish to alter his contractual terms of employment, there was a mechanism for doing that, which either was by agreement or by paying 6 months to terminate the fixed term contract. Neither of those happened. And as Mr. MUSAAB went on to say yesterday, and as I think we've established from the figures we've just been looking at, what EXPRESSO was trying to do was to pay a reduced salary, which he wouldn't accept.
Well, he accepted the money.
He accepted the money for doing additional work in Sudan and was paid a per diem compensation pursuant to the agreement that we're looking at. That is the position, isn't it?
Well, if you look at the entirety of the consultancy agreement that was signed by the other two gentlemen, Nazar and MUSAAB, the whole idea of signing that consultancy, according to the management understanding, was to settle EXPRESSO contract and to move these 3 gentlemen to be part of Sudatel management. We didn't have a say in it, and we are just suffering from the consequences of not being able to properly exit an employee from EXPRESSO to join Sudatel. Nobody consulted us when they did this.
Sorry, no one consulted you when Sudatel and EXPRESSO made these arrangements. Is that what I just heard, Mr. Aloob?
Absolutely.
Thank you. Let's move on to the next matter that you rely upon, which is at page 854 and 855.
854. Yes.
This is a letter dated September the 7th, 2009, and is sent to Mr. Nazar Sahal, who you've already mentioned. Yes?
Yes. Yeah.
The letter concludes, the letter is written by Mr. Imad Sukkar. We're not hearing from Mr. Sukkar, are we?
Mr. Sukkar is no longer with the company. I believe at the time he was acting chief executive officer and briefly even acting CEO. He was a CFO and acting chief executive officer.
Right, but we're not hearing from him, are we?
No, he's no longer with the group.
And then this letter concludes by inviting Mr. Sahal to sign, indicating his agreement to the terms of terminating his employment contract. We don't see any signature by Mr. Sahal, do we?
Honestly, all I can, I mean, look, I mean, maybe it is not here, but I'm 100% sure that he received his final dues and he closed that chapter. Him and Muhammad Sharif, the other gentleman. The same thing applied to them both.
The question is quite straightforward, Mr. Aloob. There is no signature by Mr. Sahal on this document, is there?
I cannot tell if this is his signature.
That's the signature.
This is someone else's signature.
There is a signature of Mr. Sukkar. There is a company seal.
Yes.
There is no signature of Mr. Sahal.
But I'm sure there is a proof of payment. That means he received the payment.
We can only work on the documents we have in front of us. There is,
but I cannot tell whether he signed or not.
There is no copy of any similar letter written in like terms to Mr. MUSAAB, is there?
Well, at least I'm sure they didn't join in a class action suit together. So that proves that he already accepted this agreement.
I don't know what you're talking about, Mr. Aloob. I'm asking as to whether there exists a specific document. And what I am putting to you is that there is no copy letter addressed to Mr. MUSAAB in the same terms as the letter that you have produced and seek to rely on, addressed to someone completely different, and where that person's signature was required and is not on the face of the document. There is no similar letter addressed to the claimant, is there?
Well, honestly, I cannot say that I can recall all the facts or the what actually took place at that time, but I'm sure that both MUSAAB and Nazar moved to Sudan, one as director network, the other one was director IT. And later on, they came back to us as chief technology officer and chief information officer. So I don't think there was an agreement or disagreement at that time, even if MUSAAB was not pleased with this, I never came to know about it.
And there is nothing else indicating Mr. MUSAAB's agreement to anything that you are putting forward in this regard, with regard to the defendant's case, is there?
The only thing I can talk about is what I see taking place in the office of EXPRESSO Telecom. and the items or the entitlements that he claimed, and I objected to on the basis of me being the HR expert at that time in EXPRESSO. So, for example, if someone asked for relocation and I didn't see him relocate to Dubai, and he didn't have an address in Dubai, and he didn't have a family in Dubai, or he paid utilities in Dubai, unlike the other members of the team, then definitely I will refuse to accept that. This was my standing. Nothing against MUSAAB personally, but it is against asking for entitlements that not justified.
Let's move on to the consulting agreement, Mr. Aloob. We'll find that at page 857.
Okay. 857.
And the document, the narrative of the document begins at 858 and it goes through to 860, doesn't it?
Yes.
And if we just look at 860, we can see that this document is unsigned either by EXPRESSO or by the consultant.
Yes.
It's unsealed, isn't it?
Honestly, I can only assume that this was drafted also or again by Mr. Cooke.
So because, I take it from that answer that you didn't draft it.
No.
Even though you're director of HR, you didn't draft this document.
Consultancy agreement. Normally, consultancy agreements are either drafted by the legal counsel or by an external legal firm.
And it's never run past you as director of HR.
I've seen it. I've seen it afterwards during when the dispute arises, but I cannot say that at the time I came to know about the content.
So don't come to this. You didn't draft it. No. I don't think you can tell us who did. And
I can assume Mr. Cooke.
That's an assumption. You're assuming Mr. Cooke.
Yes.
Yes. You didn't know about it at the time, but you've seen this after the event when the dispute arose. Is that fair?
Yes.
Now, let's look at this. Obviously, you weren't the drafter. We know it's not consistent with the house style that we saw in relation to the employment contracts yesterday. Yeah. It's also incomplete, isn't it?
Meaning?
Well, let's go back to page 858. You knew, or EXPRESSO knew the passport number because they had the details and could have included it, couldn't they?
Honestly, I cannot answer that question because I'm not the one who drafted this, because I'm sure I had a copy of each member passport.
Mr. Aloob, can we just remind ourselves of what you said? Let me turn it up so that I have it before me. I need to find the document. Yes. Could we just remind ourselves of what you said in paragraph 6 of your first witness statement at page 490? Could you turn up If you turn up page 490,
Okay.
and if you want to locate the document, go back 2 pages to 488. This is your first witness statement, yes?
Yes. Yeah.
Paragraph 6 on 490,
Mm.
you say the defendant decided to retain the claimant
The
as
defendant
merely a
decided to retain the
consultant.
claimant as merely a consultant as
As a-
opposed to an employee. And in this regard, the
defendant
defendant shared the
shared.
consultancy agreement with the claimant, which unfortunately the claimant never signed. The claimant at all times insisted on signing only the contract bearing the title as an employment contract. This came to my knowledge. I mean, look, this statement was made in 2019, right? The witness
Yes.
statement. However, I'm not going to claim that only came to know about this at the time. I've seen this after they left and they went to Sudan. At a certain point after Mr. Cooke left, and I was actually astonished that he shared something like this without copying me, being the HR director of EXPRESSO.
So when you,
but at the
same evidence
time,
you've given,
it was clear that yes.
The evidence you give in paragraph 6 of your first witness statement is not based on your knowledge at all, is it?
It's based on the document I found in the office.
Yes, it's based on what you found when the dispute had arisen. Yes?
Yes, and with what MUSAAB himself said to me numerous times. We had numerous discussions about this issue.
No, Mr. MUSAAB's evidence is absolutely crystal clear. His evidence is that he never saw this consultancy agreement. He said that in his witness statement, and he said that yesterday. He couldn't possibly ever have spoken to you about a document he didn't receive.
I'm sorry. I'm deeply sorry. If he said this, I'm not going to call him a liar. But again, if this is drafted, I'm sure someone intended to share it with him. Whether they did or not, I cannot further elaborate on that. Except I came to know about this from MUSAAB, that he wasn't pleased with this. I'm sure we discussed this at a certain point, and I told him clearly that I didn't know about it. I didn't have anything to do with it.
Now, can we look at page 1536, please, Mr. Aloob?
1536.
Yes.
Okay.
This is the skeleton argument put forward by your counsel, which I assume was drafted on clear instructions. Could we look at paragraph 30 and particularly paragraph 30C?
30C, clause 11 of the consultancy agreement sent to C in October 2009 contains...
Just pause it, you don't need to read any further.
Okay.
On what basis is the defendant's case being put forward that this consultancy agreement was sent to the claimant in October 2009, if you, as the only witness on behalf of the defendant, now acknowledge that you only saw this document after the dispute had arisen?
Because I'm sure one was given to Mr. Nazar, one was given to Mr. Muhammad Sharif, and they both signed, and therefore I became fully aware that this was around the time when this became available. Whether he signed or not, I'm not sure. I'm sure if he said he never signed, he never signed. If he says he never saw it, that's something else.
Mr. Aloob, none of what you have just said is from your direct knowledge at the time. It's all assumption and surmise, isn't it?
No, it is not, because the three of them, the three gentlemen, moved to Sudan. Two of them we managed to calmly, without any issues, finalize their end of service, and we never had any, or we had any frictions with them until they left. Both of them, they left the group, whether it's Sudatel or EXPRESSO. We never had any issues with them. The only issue was with MUSAAB.
Mr. Aloob, as the Director of Human Resources, if you had seen this consulting agreement at the time, you would surely have noticed the errors contained within the consulting agreement. Let's have a look at them. Let's go back to page 858, please.
Again,
858.
858. Okay.
I don't understand really where this is going, Mr. Patrick Joyce. The witness has told you that he only found out about this agreement after the claimant went to Sudan.
Yes.
So, I mean, you know, it's all a matter of argument as to whether it's accurate or not.
It may well be. Exactly, I'm not going to get very much, if anything at all, from this witness.
No, I mean, he didn't know at the time until the man had gone to Sudan.
I agree. I'm perfectly happy to move on that basis. Let's now look at events in 2014, please. And for this purpose, I think we need to begin at page 904.
904. Okay.
Now, this is an email which you sent to Mr. MUSAAB, dated the 5th of August 2015. It has an attachment, or it had an attachment, and it says, here you go. Once you send the leave balance, it can be updated, MUSAAB final dues. But I don't think we have the spreadsheet which was attached to that, do we?
Well, do you want the full story or just the part of the story?
No, I just want an answer to the simple question. We don't have that spreadsheet, do we?
The simple question is that I didn't have any accurate annual leave to include this in final settlement.
Yeah.
And I think you objected, if I remember correctly, maybe it is something different. But if I remember correctly, I think you objected to not having the annual leave accurate included to the final settlement.
Good. Well, it rather looks as if Mr. MUSAAB helped you in that regard, because if we go on to page 905, again, an email from you to Mr. MUSAAB setting out final details with the figures in dirham and in dollars, as you saw it. Yes? And we do, I think, have the attachment to that email if we go on to page 906.
906, okay.
That has the date in manuscript of the 25th of August 2014. So that corresponds with the date of the email that I've just shown you at page 905. So am I right that the document at 906 is your document, the document that you were providing to Mr. MUSAAB as an attachment to the email?
Definitely, yes. The final settlement is normally calculated by our finance team, but the emails normally sent by myself.
Yes. So you would have looked over this and you would have agreed that these figures and these heads of claim were due and owing, wouldn't you?
I'm sorry, can you?
Yeah. Well, before you sent the email.
The question.
Yeah. Before you sent the email and the attachment, you would have looked over the attachment as Director Human Resources to confirm that the heads set out there were the right heads, and you were happy for this to be sent to Mr. MUSAAB.
Yes, I would say yes.
And then we can, I think, take it fairly quickly, because what we see is a continuation of this. 909 is identified. Could you just look at 909?
909, okay.
The left-hand column relates to Mr. MUSAAB. We see what the entries are, and I think that again is an internal EXPRESSO document. The date not on the document but provided in the index of documents is the 28th of December 2014.
Yes.
And then I could go on, but we can read the documents themselves. Can I take you now to 917?
917.
Yes.
Okay.
We have a document dated the 7th of March 2016, and it follows from what you've just said that this again would be a document produced by or through you, setting out what EXPRESSO accepts is due and owing to Mr. MUSAAB, yes?
So this was in 7th of March 2016?
Yeah.
Okay. Now, if I may clear one thing, at the beginning of discussions with MUSAAB, anything they objected to that not in line with my understanding as an entitlement that should be included in the final settlement, that was the first calculation. Then afterwards, there was a talk about settlement. The minute that they started talking about settlement, then there were numerous calculations, and I had to, normally, if you talk settlement, the claimant will come from the higher ground, we will come from a lower ground, and we meet somewhere in the middle. And that's exactly what we did. Anything that originally I objected to at that time, I think I accepted in order to reach a settlement. However, the settlement was rejected by the later or previous group executive president, and we went to 0.0 again.
I see. But what I'm doing is I'm putting to you documents which originated from or through you, EXPRESSO documents. So yes. Just as we saw at page 906, the document which was on the 25th of August 2014, and just as we have seen the document at 917, which is dated the 7th of March 2016, if we go on to page 920, we have another document which came from EXPRESSO through or from you. Yes, page 920.
920.
It's an EXPRESSO document, isn't it?
920, yes.
And if we go on to 932, that again is another EXPRESSO document.
932.
932, please, yes.
Yes.
So we can see the heads, gratuity, unpaid leave encashment, ticket reimbursement. That's in relation to the second contract of employment, first contract of employment, gratuity, unpaid leave entitlement, ticket encashment, relocation allowance, salary for 7 months balance unpaid. These are all items that you are acknowledging, aren't they? Because it's an EXPRESSO document.
Yes, definitely, because it is normally shared by our finance in charge at the time, Faisal, before Faisal Abul Qasim, and both of them, they rely on a system. The minute that you exhaust one of your entitlements, it will be deducted. Otherwise, if it is not used and it is one of the entitlements that can be carried over to the next year, it will be included to your
account. But what I'm putting to you, Mr. Aloob, is that these are all...
And that's why I rely on our finance in everything. Yes.
Sorry, I don't want to cut across you, but the sound is sometimes a little bit intermittent. So my apologies, Mr. Aloob, for cutting across you.
No, it's okay. It's
But
all right. My father was a Supreme Court judge, by the way.
Well, in that case, he has a substantial hierarchical preference to me.
I'm used to this.
Well, what I'm putting to you is simply a series of documents, all of which are EXPRESSO documents, and which itemize the sums which EXPRESSO was acknowledging as to Mr. MUSAAB. And let's complete the exercise. Can we go on to 937?
937. Yes.
And that is, again, a document of exactly the type we've just been looking at throughout, this time dated the 19th of February 2017, yes?
Yes.
And for the sake of completeness, if you were to look on from page 937 through to 942, you would find in reverse chronological order all of the documents that I've just taken you to of a similar format, so that what we can see is consistency between August 2014 and February 2017, can't we?
Yes, because I believe that's when the discussions were going back and forth between us and MUSAAB, and therefore you will find different calculations. Every time he objects to one item, they go back, they calculate, they send a new calculation, and we try to obtain the CEO approval. And that was a discussion, actually. We were trying to reach a settlement. And if you look at the title, it says final settlement.
Yes, these were
when
all
you talk settlement
discussions. These were all matters which you were acknowledging. We can go on to 947.
947.
That's the final one in the sequence.
Yes.
Now, as I understand it, wherever these negotiations had reached, it was EXPRESSO's COO who refused to carry on.
Actually,
is that what you just
this
said?
Is the group president. This is the group president, Mr. Tariq Zain Al-Abdin, who is the director of EXPRESSO. The man, what do you call it? The board of directors, the head of the board of directors of EXPRESSO.
Refused to continue with the negotiations.
Well, actually, let me be very honest. I wasn't even pleased with this, because after we exhausted numerous hours trying to reach a settlement and to convince MUSAAB, MUSAAB agreed. And at the time, MUSAAB was with us in the office in Dubai during the time when he was unable to leave Dubai. He was with us in the office, and we agreed to this. And even, I'm sure there's a document that all of us signed. MUSAAB signed, I signed, the finance director signed, and we agreed to something better than this, to be honest. But the group executive president refused it. He said, no, I'm not going to pay any item that is not have something to fall back on, like a contractual entitlement.
Whose signatures are these on this page?
This is the group executive president on the right-hand side, Mr. Tariq Hamza Zain Al-Abdin, and on the left-hand side, signed 13 March 2017. This is chief, actually the vice president finance for the group in Sudan. Both of them based in Sudan. But anyway, they are the authority, the highest authority in this group.
So the position, Mr. Aloob, is you were happy to settle Mr. MUSAAB's claim, and other signatories in EXPRESSO and in Sudatel were happy to settle Mr. MUSAAB's claim, but the group president was not. He refused, and as a result, Mr. MUSAAB was not paid a pound or a dirham or a dollar. That's the position, isn't it?
Well, the time when the discussion started, I was really upset with the fact that Mr. MUSAAB actually dragged this for too long, because since the time when Mr. Nazar and Mr. Muhammad Sharif both agreed to settle the first contract, then moved to the second contract and moved to Sudan, they came back and then moved again. And I sent the final notification for the end of the third fixed term in January, I believe, or February. I'm not sure now. I think it was either end of January or early February 2014 to MUSAAB and Nazar, to inform both of them that the group has no intention, based on the instructions of the group president, that this will not happen. I actually did it to avoid the 6 months notice, or in lieu of notice, because at that time I became almost convinced that MUSAAB is setting the stage for a lawsuit, because he was trying to avoid by all means any chance to get paid.
Mr. Aloob, that is inconsistent with what you have just told us and what we have gone through. We have gone through a sequence of documents spanning 2014 to 2017, which was a process of negotiation. Are you with me so far?
Negotiations, yes, but it is not approved by the management. There is nothing I can do about it.
No, but what we reach, the position we reach on page 947, is that all of the items set out on that page were agreed in line with the previous documents that we've already seen, but those items were agreed on behalf of EXPRESSO by you and by the signatories on that page, yes?
Again, on this page, do you see my signature anywhere?
You just said you were giving oral evidence and have confirmed that you were happy with this. We've seen the signatures of other people in EXPRESSO.
Yeah, I wasn't happy with it, because after we managed to reach a settlement approved and agreed by both parties, EXPRESSO and MUSAAB, Sudatel Group, they interfered, and they actually, how can I say, we went back to square zero.
It went back to square zero, and it went back to square zero because of the group president.
Not just the group president, and I think this is shared responsibility, because my understanding, for someone at the level of MUSAAB, he should have at least been courteous enough to settle the first one, settle the second one, settle the third one, and to reply the numerous emails that we used to send to him. And now when I hear that he says that he didn't receive my email, or even if the email is sent, he didn't see it, I think that's a bit selective. That if it fits, then you say, yes, I received it. If it doesn't fit, then you say you didn't receive it.
Mr. Aloob, that is not an answer to the point that was put. But there is another oddity, isn't there? Could we look at page 456 of which is in your second witness statement?
456.
Yes.
Okay.
Paragraph 34, foot of page 456.
Yes.
You
34.
Say, do you have paragraph 34? Picking it up in the, yeah, you refer to a couple of the heads of entitlement and then continue. EXPRESSO on multiple occasions tried to make payment of these dues to MUSAAB. We even attempted to complete a bank transfer from its accounts to MUSAAB's, but received a notification confirming that the account was closed. It's clear that MUSAAB delayed payment for the purpose of building claim for a penalty. That's what you say, yes?
Exactly.
Now,
Because at a certain point, I advise our CEO to, regardless of whether MUSAAB accepts or not, my advice was to pay whatever is not disputed. If this amount is not disputed, let's pay the gratuity, let's pay all the entitlements that we agree to, and deposit to his bank account or to transfer to his bank account to eliminate the possibility of penalties. However, at that time, obviously, for some reason, his bank was not, we couldn't complete the transfer.
Well, let's take this in stages. Where is the evidence of you making one attempt to pay, let alone multiple attempts?
Well, I can go back to finance and ask them, but I'm sure for the fact that the previous director of finance and the legacy system that he was using is no longer with us, and the new finance director who actually was present during the final period of MUSAAB, which is from 2014 up to I would say 19, until he also left. At that time, we didn't have any proof. I mean, look, right now I'm unable to provide that proof, but I'm sure this is what they said. They tried to transfer the money. The money never came. The remittance advice never came back.
Mr. Aloob, you never tried to make any payment, and you can't point to anything in these papers which evidences anyone else in EXPRESSO having tried to do likewise.
Just remind of thing. I'm under oath, and when I'm under oath, whether it's in my favor or against me, I will never lie. We tried numerous times. We attempted to pay MUSAAB. MUSAAB refused, and he was actually setting the stage for this. This is my understanding, and I am an HR director. I'm 61 years old now, and based on my experience, I can swear again on my Quran next to me on this.
Mr. Aloob, what we want to hear is your evidence from your knowledge. You have no direct knowledge of any attempt to make payment to Mr. MUSAAB, do you?
I know I paid him the bail money. I know the minute that I discovered that he spent 10 days in jail without him asking, as he claimed yesterday, I managed to arrange the bail money. He never asked for it. We arranged the bail money. So we were always willing to help a colleague and a friend.
Mr. Aloob, we'll come back to the bail money as a separate item. What I'm asking you about is whether you made any attempt to pay whatever was not disputed.
I'm sure they did. I'm sure if they said they did, I'm sure they did. Right. If they are unable to provide me with a proof, considering the amount of time elapsed from 2009, 2010 until now, and the legacy system is no longer here, since at that time we were using legacy systems in the office. Now we're using Office 365 in the cloud. So definitely I cannot say whether it is available or not, but I'm sure if they said they did, I believe them.
But Mr. Aloob, if these unidentified other people tried to do this, they would have been acting flatly contrary to the refusal of the group president, because as a result of that refusal, things, in your words, went back to square zero. It didn't happen,
which is the 108,000 US dollars that is not disputed. My understanding, definitely that's the amount they tried to to actually deposit to his bank account. I don't have any doubt that they tried, because
there is no
I'm sure they are
evidence.
able to. Yeah, I mean, look, they used to pay the salaries every month, and they are bound to confirm the account balance to the auditors. We are bound by this. Our auditors, the external auditors and the Sudan government auditors, when they audit this office and the books of EXPRESSO every year, we have to provide proof of the balance accumulating for any staff. As long as there is a balance, that means the money is there.
If any of this had happened, we know from the evidence that we've just been looking at that EXPRESSO was in direct contact with Mr. MUSAAB through until 2017. You could have asked him if you were having problems paying at any stage up to 2017, couldn't you?
No, after he left Sudan, after the end of his entanglement with UAE law, and he left the UAE, he was no longer in touch with us. I know after that time, there were discussions of settlement again with the group, I think the VP Finance or the group executive president in Sudan, but we weren't part of that. And that was during the time when he lost
page 943, please, Mr. Aloub.
Page
943.
943. Okay.
That is an email from Mr. MUSAAB to copied to you, sent primarily to Mr. Faisal, providing information about the period of his unpaid salary, and that has his email address at Sudatel. If you'd wanted to pay, not you personally, if EXPRESSO had wanted to pay, quote, everything not in dispute, and if there had been difficulties in paying into a bank account, up until February 2017, you could have found out all relevant details by the simple expedient of sending an email back to this address, couldn't you?
Nobody asked me to provide it, and that's why I never looked for it. If you want me to look for it now, I can. I'm sure.
No, because we've got all the information that we're ever going to have in the papers before us. Yep. And what let's just look at page 465, please.
65.
Paragraph 28, what Mr. MUSAAB says. He said that he had 2 UAE bank accounts. Oh, sorry, do you have it?
This is 965.
465.
Excuse me?
465.
465.
Yeah.
Okay.
He says that the defendant had been provided with the details of his 2 UAE bank accounts. One of the accounts remains open to date, and he exhibits proof of that, which is to be found at 1556. But that's never been put in issue, that the bank account remained open throughout the entirety of the time in question, and is still an active bank account now.
I cannot answer to that. Maybe he had numerous bank accounts.
But if he had numerous bank accounts and you had those details and those bank accounts remained open, EXPRESSO could have made payment, couldn't it?
No, because normally it is the bank account available with our finance.
If you have the details of his bank accounts and those bank accounts remain open, you have the means of making payment, don't you?
I assume yes, but
your finance department didn't make any payment at all, did it?
well, for someone who actually, my understanding, if your residency expires in the UAE, automatically the bank will inform you to renew your residency or to provide the renewed residency and Emirates ID. Failure to do so can result in the bank account being seized or closed.
But that
So
isn't
after
this
his
case.
legal entanglement, I assume that that was the case. I'm not sure.
Well, that isn't this case, because Mr. MUSAAB has produced unchallenged evidence of the continued existence of his bank account in the UAE. That is what page 1556 does.
All the evidence or the claims or anything he provided is after 2016 and 2017. But again,
well,
this
before
is
that you were talking to him,
to
and
that
after
time,
that he provided you with the information. Is that the position, Mr. Aloob?
but that time it became very difficult to end this because the group already, the group president and the VP finance were involved, and they were leading the discussions. And even I know that MUSAAB appointed a friend who was leading the discussions with the group in Sudan. And suddenly afterwards, I discovered that he filed a lawsuit against Sudatel in Sudan. And I believe he lost that lawsuit. And then suddenly we received the notification of the legal notice here. And
Mr. Aloob, once again, none of your answer is relevant to the question that I posed. Let me ask you finally to look at page 451, which should be the first page of your second witness statement.
okay. Four, 5, 1.
Yes. And if you go on to page 457,
5, 7.
yes, you see section H.
Okay.
You see section H at the foot of, towards the foot of that page.
Yes.
Would you just read to yourself paragraphs
Yeah.
4 and 5? So 457 going over to the top of 458.
Do I need to read it out loud?
No, just read it to yourself, just refreshing your mind.
Okay.
And you've had an opportunity to read up onto 458 as well, the complete text.
Okay.
Are you happy that what's set out there is true and accurate?
Excuse me?
Are you happy that that is accurate? And you've given a statement of truth at the foot of page 458. So you said there that you believe the facts stated in the witness statement are true. I'm just asking you to confirm that, having refreshed your mind about these paragraphs, that those paragraphs are true and accurate.
Yes.
It probably becomes a matter of submissions in relation to how the bail was to be dealt with, but you provide information at the foot of page 457, the truth of which you've just confirmed.
Yes.
Your Honour, I think that concludes my questions, but may I simply have 2 or 3 minutes just to take instructions from Dubai to make sure that I've covered everything that I should have done?
Yes.
I'm very much obliged. I'll switch my microphone and camera off.
Okay.
I'm obliged, Your Honour.
Thank you very much. Any re-examination, Mr. Doherty?
Just two, I think, very short points, Your Honour. The first one, Mr. Luke, can I take you back to page 854?
Yes, 1 second. 844.
854, 854.
854.
Yes.
Yes.
As I don't know how much turns on this, but you were taken to this document and you looked at page 854 and then you were shown 855. And it was put to you that Mr. Cooke signed this document, but that the person it was addressed to, Mr. Sahal, didn't.
Yes.
And really, this is just upon review of the document. If you could look at page 854.
Okay.
In the bottom right-hand side of the page.
Yeah.
And it was suggested to you that there were no other signatures on there. There appears to be, it's quite faint, just above where it says 92 page. You see that just above. Yeah. Are you able to help us and tell us what that is, or on your view, what that is?
Unfortunately, I cannot be 100% sure because I assume it's an initial. It is not a signature because I'm familiar with the signatures of almost everyone involved in this. But I think this is an initial. However, I'm 100% sure that this was accepted by Nazar and the other gentleman.
Okay, thank you. So, sorry, just to be clear, you say that that's an initial?
Yes.
Yeah, okay. And then the final very short question at page 1556.
1556.
Yeah, it's the document you were just taken to very recently.
Yeah.
It's really to clarify what was asked of you about this document, because I think what was being asked of you was to confirm that this document showed that the claimant had a bank account open that you could have paid into at the time from 2014. And I just want you to look at the document. You'll see in the middle of the page on the right hand side, it says period 12th of January 2023. And if you go down just below that, it says account status
again
active.
You said one.
Sorry,
1555.
1556.
1556. Yes.
So you see
which is the consolidated bank statement.
That's right. And on the right hand side in the middle of the page, it says period. And you see it says 12th of January 2023. And just below that.
12th, yes, 12th January 2023. Yes.
Yeah, and just below that it says account status active. And so I think it was being put to you that this document shows that there was an account open at the time that you could have paid into. And the question that I have for you is, does this document say anywhere when this account opened?
No.
Okay, thank you. That's all I have.
Thank you very much, Mr. Aloob. Those are all the questions. Those are all the questions for you, so you're free to come or go as you wish. Thank you very much.
Thank you very much.
Right. Timetabling, Council.
Yes, Your Honour. I think we are up with the clock. I'm just looking for my copy of the timetable itself.
Well, you're slightly behind, but I don't think it's probably going to matter very much.
No, because I think we've got quite a luxurious time frame. There we go. Time frame for closing submissions. And I'm mindful also that we have to look at the clock at some stage. What was planned was a 10-minute break. followed by closing submissions. This has me closing before the defendant, but and I'm happy to take whatever course the court sees appropriate. But my learned friend has certainly reserved the right to go into greater elaboration of the law, and I understand, though I haven't seen them, or at least had an opportunity to look at them yet, that my learned friend is relying on 3 further authorities, and obviously I would need to respond to those as well. But I'm in the court's hands, really, as to where we go in terms of break, closing submissions, order of closing submissions, lunch and housekeeping.
Yes. Well, obviously, I've had a chance to look at the authorities and so on. I'm not sure that extensive elaboration of them is necessarily going to help, though I'm not going to stop anybody. What is likely to help me most, and the areas I would like the greatest assistance with, I think, are what the evidence really shows about the question of where the claimant was based and from where he worked for the purposes of the application of Section 4 of the 2012 employment law. And I have 1 or 2 questions about what the phrase termination means in the context of the employment law, and indeed in the context of the agreement sui in particular. I've looked at both, obviously at the Court of Appeal decision in this case, and at the industrial group case, likewise, at Furco and Fernando also. So the parties can certainly address me on those matters, but probably without necessarily going into great detail. I think that's as much as I can do in sort of helping you as to the areas that I particularly want assistance with. But if you start on a subject matter where I'm with you or have reached a preliminary view of one kind or another, I may well indicate that to you so you can move on more speedily and dwell on matters that matter more so far as I'm concerned. But having said all that, I understand you're not necessarily in agreement as to who goes first and what the most sensible course of proceedings is.
Your Honour, I should say I don't have a particularly strong view, so I'm happy to go with whatever order of play you think is going to help you the most. I can go first or second. I don't think it makes a huge difference from my perspective.
Well, I think probably it's easiest if Mr. Patrick Joyce goes first and tells me why claims under agreements 1 and 2 aren't time barred. And then we'll see what the position he is, if Mr. Patrick Joyce particularly addresses me on the other matters that I've mentioned. Then we'll hear Mr. Doherty, and if there's any need for a reply from Mr. Patrick Joyce as claimant, he can have the last word. So that's broadly how I see it. We're now at 10:25. That's 1:25 Dubai time. So is it sensible actually to take a significant break at this point, which would enable you just to organise your thoughts in any event if there's anything that needs further organising as a result of this morning's evidence?
Well, Your Honour, that's certainly, I would be much obliged for more than the short break that we had yesterday at this time, but not an excessive length of time.
Well, Should we take half an hour? Is that what you're thinking at this point?
Yes. What I might propose is if we could have 40 minutes at this stage, I can spend 10 minutes buying some sandwiches, half an hour thinking about it. Then when I've made my submissions, Mr. Dirt, we might have another half-hour break or a short break, and we can continue on that basis. And I can have my sandwiches in the second break.
How long do you expect to be in addressing me?
Oh, I would hope to deal with it. I am a time optimist. So let me say somewhere between half an hour and 3/4 of an hour as I presently see things, given the questions that have been raised. Beforehand, before hearing the helpful comments from the court, I overnight looked in considerable detail at the Court of Appeal and TIG again, and there may be an alternative basis on which I would put the claim, particularly given that TIG is Court of Appeal, and therefore, unless I can distinguish it, it's going to be binding on this court. So I think I should probably say a little bit about that, but I have that in note form.
Is that specifically with regard to the penalty payment?
It is with regard to the penalty payment. Yeah.
Well, I mean, on the face of it, you know, I'm bound by that, aren't I?
Well, you are bound by it. It's just whether, obviously, there are two questions: whether it's right and whether it's distinguishable. And I'd have to get, hit the bullseye on both.
Yes.
Yes.
Right.
So and that's why I want to put it on an alternative basis. They're reserving my right to reopen matters at an appropriate stage if we get there. So that's where I would be on the sort of. It also follows on from your lordship's question or your honour's question about abuse of process yesterday, as that again is dealt with in TIG.
Is it? Yes.
Yeah.
I didn't pick that up because I focused on other bits of it. But
yeah,
what do they say about that? Anything?
Well, yes, because they consider the law not only in relation to malicious prosecution, but expressly on abuse of process, which is issue 3, and
as
on
a tort.
As a tort, abuse of process as a tort. Yes, and on issue 3, the claim based on abuse of process, so focusing narrowly on that, leaving aside malicious prosecution for present purposes, that was dismissed by the Court of First Instance. And the Court of First Instance analysis is recorded in the Court of Appeal judgment at paragraphs 23 to 24 and 98. And the Court of Appeal dismissed the appeal essentially at paragraph 106 for reasons set out and discussed in paragraphs 103 to 112. So it does deal with abuse of process.
Understood. I mean, I think the position is that abuse of process hasn't been relied on, whether as a tort or as a procedural matter. But it's hard to imagine that the idea of procedural abuse didn't cross the minds of all the courts that previously had considered the penalty provisions and thought that they were unjust. So I'd rather assumed that it probably had been discussed and ruled out as a way around the statute, so to speak.
Well, I can't help the court as to whether it had been ruled out at an earlier stage, but it has certainly been ruled out as a tort in the DIFC.
I understand that as a tort, but the question I have is...
Oh, yes, a procedural abuse of process, yes.
You know, I've had courts to consider this in other contexts. There is undoubtedly a difference between what the court can do as a matter of its own procedure, where there is an abuse of its process by a party misusing the court's procedure, as opposed to the tort, where different elements actually arise in order to prove the tort. But Mr. Dockett doesn't appear to rely on that in any event, so it may be no need to go there. It may be a point that's better reserved for reply should Mr. Dockett suddenly decide he wants to rely on it.
Yes. Well, I have a note on that point, and I've read part of it into the record. I was also going to take the court to the list of issues in case that was helpful as an aid memoir. That's at page 1553 to 1555. And then my third point in relation to closing was reserving my position to comment on anything that my learned friend says by way of law, which he hasn't opened thus far.
Yes, of course. All right.
Unblush.
Well, we're now at
10:34. Quarter.
Okay. Well, let's. You want 40?
I was thinking of 40. Of course, my learned friend will be able to use the time as well for his preparation.
Yeah, call it 45.
I don't think there's
45 minutes. Essentially, will take us to 15:15.
Yeah.
All right. So we'll come back at 15:15, which will enable people to get a bite to eat in Dubai, and then we'll take a short break between the two lots of submissions.
I'm very much obliged, Your Honour.
All right. Thank you very much. Very good. Are we all set to go?
Yes, Your Honour.
Thank you very much. When you're ready.
You're obliged. Your Honour raised 4 points of specific interest, and I will deal with those first before reverting to the other aspects that I intend to cover by way of closing. Your Honour first asked for the evidence which showed or which went to the question of where the claimant was based for the purpose of Section 4 of the 2012 employment law. I think the starting point in addressing this point is probably to recall the way in which each of the 3 agreements in question was described, and in particular how EXPRESSO Telecom Group is described in each of them. We can look at all of them for the court's reference. The page that I will be referring to is in Agreement 1 at page 793, in Agreement 2 at page 877, and in Agreement 3 at page 889. But suffice it to read into the record what's said in the first agreement, because it's common to Agreements 2 and 3. EXPRESSO Telecom Group Limited and registered in the Dubai International Financial Centre, the company. And I accept that it goes on to provide an address in JLT, but that was corrected, or at least the proper position so far as the DIFC was concerned, was dealt with in the cross-examination of Mr. Aloob. You'll recall the evidence yesterday. I took Mr. Aloob to the full record of registration in the DIFC. He accepted that.
Well, I understand that, but there's what he told us was that the office they planned to occupy wasn't erected, which is why they had an office in onshore Dubai. He said, and that's the question, first question, assuming for the moment that he is, quote, based in Dubai, his office on his evidence is in onshore Dubai, not DIFC. Well, now, I know it's a company registered in the DIFC, and they then had permission from the registry to have that office there. But how does that work in this context?
Well, no party can benefit from its own oversight and omission. This party, EXPRESSO, clearly represented itself as registered in the Dubai International Financial Centre.
It was.
And that, indeed, and that, Your Honour, is the that really is going to be the answer, because Your Honour must recall the gateway under the Judicial Authority Law as amended, Gateway 5A1A, And that provides that the court of first instance shall have exclusive jurisdiction to hear and determine civil and commercial claims and actions to which, inter alia, any DIFC establishment is a party. Now, when one then looks, and I'm happy to take you to it, I'll have to move off the camera screen to another screen. When one goes back and looks at the definition of DIFC establishment, which is identified in Gateway 5A1A, separate and distinct from a licensed DIFC establishment, it is plainly of an extensive definition, and it plainly covers the claimant. So once the claimant is established, as we have done, as being registered in the DIFC, Gateway, the Judicial Authority Law and Gateway 5A1A provides a complete answer to any suggestion that this court doesn't have jurisdiction.
No one's suggesting this court doesn't have jurisdiction. That's not the issue.
Well, then one goes on to the governing law, and the governing law says the DIFC laws shall apply. Now, it would be, in our submission, a complete nonsense and travesty if one reaches the position that this is a DIFC establishment entering into a contract which it itself says is subject to the DIFC laws, and then because of the circumstances, it can be said that the employee, even though expressly subject to the laws, is somehow outside the law which is expressly referred to, because that employee is not based within or ordinarily works from the DIFC. So within or ordinarily working within or from the DIFC. In our submission, working from the DIFC, when the employer is registered in the DIFC, has entered into the contract of employment on the basis that it is a registered DIFC establishment, plainly, the basing of the employee follows from the base chosen by the employer. The employer has chosen the base of the DIFC, and the employee falls into line with the employer's choice. By not exact analogy, one might think of the seat of an arbitration, but here it's even closer. The relation is closer through the registration and the choice of law. It is in our submission express, whereas seat of arbitration, the base of the arbitration, can be really quite elastic in certain circumstances. The same elasticity nothing like the same elasticity needs to be applied in the present circumstances.
Okay.
Unless I can assist the court further, we say that is a complete answer in the claimant's favour to the first point that was raised and on which the court asked for assistance.
Well, I'm not sure that's quite right. Let's assume that I'm with you on that. So far, so good. We then have the provision in 1.2, the place of work shall be the company's Dubai office, reserves the right to require the employee to work elsewhere, and so on.
Mm-hmm.
And what I'm really asking, the other question I was asking about is what the factual evidence shows in relation to his, quote, place of work, and how he operated on the ground, so to speak.
Well, I accept the factual evidence showed that he had places of work in really multifarious places. He was never in any one place for longer than a week or so. He was in Dubai, he was in Khartoum, he was in Dakar, he was in Madrid, he was looking after the consortium arrangement in relation to the submarine cables. Now, that in our submission is very similar to a lot of regular travellers from banks and other financial institutions, establishments in the DIFC. It would be a travesty for any court to conclude that such employees, including the claimant, is not based in the DIFC because of the way in which their physical work takes them hither and yon.
Well, I understand that so far as that point goes. There's a difference here. I mean, in the ordinary way, of course, as you say, all sorts of employees travel all over the world on their jobs and may spend very little time in their home country. But actually, of course, his home country is Sudan, and was Sudan. He told me that in terms throughout the whole of agreements 1, 2, and 3. So, and because of the Sudatel setup, and however one puts it, there plainly is a restructuring of some kind that goes on, which results in the Sudatel contract being entered into. Is the reality that his base of work ceases to be the DIFC, regardless of what appears in the contracts, agreements 1, 2, and 3, and becomes Sudan? That's the question that I have to grapple with, I think.
Well, Your Honour, if EXPRESSO had sought to achieve that, then it goes back to the evidence that Mr. MUSAAB gave in cross-examination that he knew about the restructuring. He was open to discussion. But if they are going to do that, then they have to deal with the Contract of Employment Agreement 1 in a proper way, by negotiation, by an agreed termination in writing, by 6 months' notice, and not by oppressively trying to arrange things such that he does the same work for half the pay. That none of that took place. So the employer remained subject to Agreement 1, and he performed well in that. He got promoted. Agreement 2 performed well in that. Agreement 3. And at each stage in that series of employment contracts, each and every one of them prefaced with the words registered in the DIFC. So the base, the employer's base, is in our submission plainly identified as being the DIFC, and it would be extraordinary if, having identified that as its base for the contractual purposes, for the law not to apply.
Right. Okay.
And again, I'm happy to answer any supplementary question, but I hope that answers Your Honour's supplementary question. It's no different from people travelling to all sorts of places, but they remain based in the DIFC for legal purposes. It is a legal base. That is what one is seeking to identify, and the legal base has been identified expressly on the face of each of these 3 agreements, and those agreements continued. They were not terminated. Well, they were not terminated by notice. That, I think, brings me to the second point that Your Honour raised with me, and that is, what does the phrase termination mean in the context of this employment law and also Agreement 3?
Yes.
And I don't wish.
I don't want you to take me through your arguments about the 6 months in lieu of pay in lieu of notice point.
Well, I was going to say that you have those points. Yes,
I got all that, and I'm against you on that. It's plain to me that in that context of Clause 13 and so on, it's talking about an early termination prior to the expiry of the 2-year time limit. But what is interesting is that, of course, it may mean different things in different parts of the contract, and particularly in the context of the legislation, where termination doesn't appear to mean necessarily, indeed it can't mean, seems to be, a formal termination by either party. but would include the position where there's expiry of a fixed term contract for which provisions made in Schedule 1, and where there is, it's referred to as the effective date of termination being the expiry of the contract.
Yes.
So I take termination in the context of the legislation to mean expiry of the fixed term contract with all the penalty provisions that apply if you don't pay up on wages and amounts due within a period of 7 days or 14 days, depending which bit of legislation you're looking at. So I take it that that is your submission, if I'm against you on your contractual construction relating to the 6 months pay in lieu of notice.
Well, in that regard, if you're against me on the contractual point, then there are obviously statutory provisions in relation to that, and then one is looking at calculating the years of service. So that termination can have a different meaning, even yes. So that termination, sort of formal termination of a series of fixed term contracts, is very different from the termination at the end of the series. And I think that that may be the point that Your Honour is getting at. And if Your Honour is drawing a distinction between termination and rolling over and termination cut off dead, then I would respectfully agree with the court's view that there are two very different bases. And of course, at the end of the termination, the cut-off dead termination, that must take account of all of the year's service and the continuity which went before. Is that, again, without going over ground which I've already covered on a different aspect, have I addressed the point that the court was raising with me?
You have, and I'll hear what Mr. Doherty has to say, and if I need to reply on it, I'll ask you.
I'm very much obliged. Your Honour, the third point was in relation to the Court of Appeal decision in this case, but also the Court of Appeal decision in TIG. And Your Honour has had the kindness to indicate that you've read Furco and Fernando, so I won't go into that because it's a very short case and the point is very clear from paragraphs 3 and I think 9 to 11, the paragraphs that I mentioned in the skeleton argument. So far as TIG is concerned, as Your Honour is aware, that case really had three broad elements. One was penalty, second was holiday pay, which was fact specific, and the third, which I've already touched upon, was the DIFC law and torts of abuse of process, not procedural aspects. I don't have anything more to say in that regard because I can't shed any light on wider aspects of abuse of process. But
Can we just have a quick look? Can we just have a quick look at that? Or were you going to take me to it?
Well, I'm going to take you to. I was going to focus on penalty.
Yes.
But
well,
I've also provided what I think are the cross references for abuse of process. I'm happy to go to that perhaps at the end, treating issue 1 first and issue 3 next.
Yes, as long as you come to it at some point. I'd like to look at that case with you at some point.
I think we're going to look at the case now, Your Honour. It's just the sequence in which we look at it. But as for issue 1, in TIG, the claim was made before the 2019 employment law was enacted. It was enacted on the 30th of May 2019. And the law was effective 28th of August 2019. We find that, for Your Honour's reference, at paragraph 15 of the Court of Appeal judgment. So we are into the complexity of the waiver provision of Article 19.2 and 19.4a, and that's so what arose in TIG, paragraph 17, does arise here. The interaction between the 2005 employment law and the 2019 employment law was considered by the Court of Appeal at paragraphs 26 through to 73 of the TIG judgment. And rather than talk about the employment law each day, I'll just talk about the 2005 law and 2019 law, if I may. Articles 1, subarticle 3 to 5 of the 2019 law are set out for the court's reference at paragraph 28 of the TIG judgment. And of course, the 2019 employment law has itself been amended in 2021 by the deletion of Article 1.5, which was enacted as part of the 2019 law. That article is discussed in more detail at paragraphs 66 to 71, but I leave it aside for present
obscure,
purposes.
isn't it?
It's mind-bogglingly difficult to work out. I leave it aside for present purposes, but I don't abandon, in the fullness of time, if necessary, arguments on what Article 1.5 meant. But for present purposes, I think we can fish in other waters. The conclusions of the Court of Appeal on the statutory scheme are, in my submission, expressed in paragraphs 53 to 72 of the TIG judgment. Even there, I would say much is unclear about the statutory scheme, but there is one point which is absolutely pellucidly clear. It's remarkable how clarity is always pellucid. Perhaps I should avoid using the adjective. Paragraph 54, what the Court of Appeal said in relation to Articles 1.3a and 1.3b was that in shorthand, rights accrued prior to the commencement of the 2019 law are not affected by its coming into force. And that is the savings provision, and thus the right to a penalty calculated daily until the 28th of August 2019 is clear. And insofar as that conclusion were not clear from paragraph 54, it's clear from paragraph 55, because that's what paragraph 55 says. So the Court of Appeal then held that after the entry into force of the 2019 law, there was, this is about the discussion of the trammelling or untrammeled right, which seems to have arisen at two distinct junctures in the course of the submissions. But the Court of Appeal finds that there was no untrammeled right to a penalty until payment, really in paragraphs 57 to 59 is where that discussion takes place. But the Court of Appeal was also at pains to point out, and this is in paragraph 62.3 on page 19 of 34, in construing the 2019 law, they say, and it speaks only as to the future, and at most prevents the future accumulation of penalty payments during the currency of relevant court proceedings. Now, the Court of Appeal has included those words "at most." Where
are you in 62?
62.3 on page 19 of 34. If you're looking at it in the bundle, it's page 1514. 1514. Now, that express inclusion of the word "at most" is, in my submission, interesting, informative, and indicative. And it's indicative because obviously what one must do is attempt to identify with precision the ratio of the Court of Appeal in TIG, and it seems to me that it is not totally clear as to what TIG does decide. It may be that it's saying that a penalty claim should be calculated up until the 28th of August 2019 because the law changed, and once the law changes and there's dispute on foot, then on that basis, since that date, a dispute has been pending so as to trigger the waiver provisions. But that's not completely clear. And were I re-arguing it, and I accept with the caveats that we're at a court of first instance, the real question in my submission is whether the statutory scheme provides an accrued right to a penalty, which is variable only according to the length of time and therefore the number of days over which the penalty is to be calculated. So is it an accrued right, or whether the scheme provides for a series of rights to a penalty, which rights accrue daily? And there's an indication, I haven't gone back to the court of first instance in TIG, but there's a very clear indication earlier on in the Court of Appeal judgment that the same issue was grappled with by Sir Richard Field at first instance. And I must say that in my submission, the statutory scheme plainly does the former and not the latter. In other words, the statutory scheme creates a right to a penalty, that is an accrued right variable according to length of time, not a series of accruing penalties. And indeed, if one looks at what the Court of Appeal said, for example, I haven't done a complete word search, but if one goes back to paragraph 59 on page 1512 of the record, what the Court of Appeal says is we do not think that Article 18 of the 2005 law future-proofed the right to a penalty. Now, the right to a penalty crystallizes at the time that Article 18 says it crystallizes. So in my respectful submission, I would, and I do accept, I have to say, I'm not overlooking that Article 1.4 does refer to a reduction or extinguishment of rights. But in my submission, that doesn't really apply here, because what we're talking about is not at all a reduction or an extinguishment of a right. We've moved from the existence of the right to question of quantification. And furthermore, so that the right remains crystallized, the right is unaffected by the apparent narrowing in Article 1.4, and then one must, in my submission, dovetail that with what a savings provision does. TIG at the Court of Appeal acknowledges that ABDELSALAM in the Court of Appeal had addressed the question of savings provision, and it does so at two instances. If I can look first of all at paragraph 74, which is on page 416. I'm sorry, Your Honour.
Yeah, no, I've got it.
Paragraph 74, it was not suggested in argument the lawmaking power of the ruler in relation to the DIFC does not extend to the power to enact retroactive legislation, including laws which, by repeal of a pre-existing law, might extinguish rights or liabilities agreed under it. However, the courts of the DIFC would be slow to construe a saving provision, such as Article 1.3, so narrowly as to have the effect unless the language of the saving provision required a narrow construction. That would accord with the approach of the DIFC courts, which has been described as developing DIFC and law and shaping principles taken from various common law traditions. So what one has there is the broad principle applied in a particular instance, but the broad principle that unless constrained to do so by express wording, a saving provision should not be construed narrowly. And then if one goes on to paragraph 83 on page 419, an article that the learned friend has already read into the record, but it repays a revisitation. This grapples with Article 1.3. In the particular context here of Article 10, that's water under the bridge, and we're not talking about Article 10, but again, one's looking at general principle. It cannot be Article 1.3a, question is what aspect of Article 1.3 is subject to Article 10. It cannot be 1.3a because Article 10 doesn't in terms apply to rights, remedies, debts or obligations. What operation then does Article 10 have consistent with the language? Plainly, it can operate in respect of that class of legal proceedings referred to in Article 1.3b, any legal proceedings to be commenced in respect of, etc. So it then goes on to talk about Article 10, and I can skip, I think, to the last sentence, which begins on the right-hand margin 3 lines up. The evident purpose of the provision is to pick up employees who may be, as it were, resting on their rights. Sorry, I think I should read the sentence before. Any employee who had not commenced a legal proceeding under the 2005 employment law within 6 months of termination of his or her employment at the time that the 2019 employment law came into effect would not be able to have that claim considered by a court. The evident purpose of the provision is to pick up employees who may be, as it were, resting on their rights in order to gain the benefit of a claim for penalties which might accrue against the employer following termination of the employment. What's concerned here is that prospectively, from the passing of the 2019 law, that prospectively puts an end to the 6-year time limitation. And that is essentially what is being said here. But you go back to the provision of the first sentence that I read, any employee who had not commenced a legal proceeding under the 2005 employment law within 6 months of termination of his or her employment at the time of the 2019 employment law coming into effect would not be. So it's only if you don't start within 6 months in 2019. That doesn't affect what went before. So that, in my submission, is of a piece with the saving provision being applied broadly, and the real question being, what is the nature of the right? Is it a right to a penalty accrued if payment isn't made within 14 days after the termination, which I say is the case, or is it somehow a continuing accumulation of rights? Although now is not the time to do it, it does seem to me that there is further argument to be had in that regard. But that takes me, I think, completes the analysis, save for this. If the court of first instance, if Your Honour is either unimpressed by my argument or feels constrained, whether irrespective of the merits of my argument, by what the Court of Appeal has said, and feels therefore that the claimant has only an entitlement to a penalty up to the 28th of August 2019, then for the court's benefit, that period of time from the 15th of August 2014 to the 28th of August 2019 is a period of 5 years, 13 days. That's 1,475 days. The relevant daily rate is $672, and 1,472 times 607, 1,474 times 672 is 990,528, 990,528. So
just give me the, it would be 5 years, how long?
5 years and 13 days between the
Yeah.
15th of August 2014
Yeah.
to the 28th of August 2015. The period of 5 years and 13 days, taking account of one leap year in the middle, is 1474. The relevant daily rate is 672.
Yeah.
1474 times 672 is, according to my pocket calculator, 990,528.
Okay, thank you. Yep.
Now, that leaves me to deal with TIG insofar as it relates to abuse of process. And Your Honour indicated an interest in being taken to the relevant paragraphs. Yes. They are 23 and 24. And of course, in saying that it deals with tort, the tort of abuse of process, I was taking that from the issue, the heading and the discussion. And it certainly seems to be that it's limited to torts, because it then goes on to relate the common ground to torts being provided exhaustively and exclusively by the Dubai Law of Obligations 2005, and then proper construction of that DIFC law. Now, just to jump about a...
It's all relating, is it, to the malicious prosecution relates to the criminal complaint?
Yes.
Right. Forgive me, I'm not sufficiently familiar with the background facts to know the basis upon which the tort was being alleged of abuse of process. Can you help me on that?
Yes, the background facts were really quite egregious. Mr. El Hamid was essentially the right-hand confidant of the chairman of the industrial group, and he fulfilled a really very important role by paying large sums of money for the chairman's personal expenses and being reimbursed, etc. Right. But they then fell out, and it was essentially an engineered arrangement with an attempt to get Mr. El Hamid arrested. It's set out in the background. I don't want to, even though it's an occasion of qualified privilege, I don't want to say anything which is defamatory, but the Court of Appeal was absolutely clear. What I've summarised really began at paragraph 7. Paragraph 8, the Court of Appeal says TIG subsequent conduct can only be described as disgraceful, including the wholly unfounded allegation Mr. Hamid's recouping of such payments was irregular or dishonest, and a criminal complaint made by TIG occupied over a year of investigative time and was ultimately dismissed. And unsurprisingly, Mr. Hamid claimed that he'd suffered hardship and distress.
Okay, so that's... But is that just related to the criminal prosecution? You know, I'm just looking at the...
Well,
where's the abuse of process allegation is really what I'm asking.
That is a good question, Honor, because towards the end of this, and I hope I can find it quickly, there is reference to defamation. Yes, paragraph 109. Paragraph 109 certainly talks about defamation, and I had read the reference to defamation as really being the flip side of the malicious prosecution. But actually, could I take Your Honour to 109, page 1524?
Yeah.
because it looks as if there is a putting together of malicious prosecution and abusive process. The last 5 lines of 109, though our decision does not rest on an explanation for the absence of any provisions dealing with malicious prosecution and abusive process, it may be that, as with defamation, it was at the time thought that these were matters for criminal courts. So if there is anything between malicious prosecution and abusive process on these facts, it's paper thin.
I'm being very dense here, I think, because I'm not sufficiently familiar with the facts, but the abusive process argument, did it relate to the civil proceedings or to the criminal proceedings?
Well, it was raised obviously in the civil proceedings, but
yes.
that I don't think is the point that Your Honour is making. I do not think that, again, I'm happy to stand corrected, but I think that the abusive process was the fact that criminal, an unfounded criminal complaint had been made.
Yeah, I understand that. I mean, it's probably not now the time to go into it, though I think it's a matter of some interest. Mr. Doherty, I don't think, has relied upon any allegation that the claim that is being pursued in these courts by the claimant has become abusive because of the length of time taken and the 8 variations of the particulars of the claim and the like. But it occurred to me, and it surely must have occurred to others before, that a potential answer to the penalty point could be something of that kind, whereby one could say, no, we're not allowing this claim to run on beyond a certain limit because the claimant has abused the process of the court by messing about and doing lots of silly things. Do you know whether that's ever been argued as such?
I don't, and I'm sure that if it had run full course, then it would have been reported. So,
and it would need an extreme case, of course. I mean, you know, to even begin to think of running the point, you'd need a very extreme case. But having said that, when you're running into cases that go beyond the limitation period and so on, one does begin to think.
Well, Your Honour, I do want to say something for the record in that regard. It's very important because my client feels very strongly that such delay as has occurred is not something which can be laid at his doorstep. And the reason for this...
At his personal doorstep.
Yes, at his personal doorstep.
Yeah,
the first point, obviously, is that he may not have been fully and effectively served first time round in his original legal representation. I say nothing more than that. But when one boils down the problem, the perceived problem, with the original particulars of claim, an exercise that I had to do only too laboriously very recently, one sees that actually there wasn't a lot wrong. All that happened was that there was a reliance on a piece of legislation which hadn't been enacted. But the facts were there and the core law was there. And although now is not the time to go into this in any great detail, I would want to go through all of the 20-odd documents that the learned friend has referred to quantitatively and look at whether and why and whether those were strictly necessary in order to keep this litigation moving forward. In other words, I would submit that a lot of the delay has been contributed by the overly punctilious approach adopted by the other side, where there've been schedules of minutiae in relation to comparing one pleading with another pleading. Completely unnecessary.
Well, I understand all of that, and I say I don't think Mr. Doherty is pursuing the point in the context of saying that you're shut out from the penalty because of some abusive process.
No,
however, so questions of blame don't really arise. But there's a more fundamental point which arises to my mind that I shall need Mr. Doherty to address me on. But it's this, that it's the point essentially made by the Court of Appeal that a cause of action is constituted by facts, and it's you don't need to plead law. And certainly conventionally in common law jurisdictions, you don't plead law, though sometimes it's regarded as helpful in order to indicate where you're going. And so therefore, if you've pleaded the facts that give rise to individual heads of claim under a contract of employment, the penalty provisions then come in as a matter of law automatically, and therefore don't need to be pleaded beyond saying no payment was made of any of the sums in question within 7 days, 14 days, or at all. And that's all you need, it seems to me.
I would respectfully agree. And if there was a greater understanding of the purpose of pleadings, the purpose of evidence, and the purpose of submissions, then rather than triplicating at each stage, anyway,
it's a thing that I feel very strongly about, because it's, I'm afraid, a commonplace in this jurisdiction, in Singapore, where I also sit, and increasingly, I'm afraid to say, in the UK, that people have lost sight of the purpose of pleadings, and it's partly because they do so much arbitration that they think that they have to put all the arguments into a pleading, instead of just pleading the bare bones of facts on which they rely for the cause of action. And it's unfortunate, because it means that there is a huge amount of extra time and cost involved, both from the point of view of the parties, and simply it wearies the court, if I can put it that way.
Well, Your Honour, I was going to add arbitration to the defaulters list, but you've done that for me. The idea that you get 90+ pages of reply in a straightforward arbitration is extraordinary. But yes.
Right. Okay. Well,
yes,
I think we've covered the ground, haven't we?
We probably have. I just wanted to circle back to the last. To say that the abusive process is discussed between paragraphs 103 and 112 for Your Honour's note, and really I think the decision is in paragraph 106. I said that I would very briefly go to the list of issues, and it may be convenient if I just very quickly run through those, Your Honour.
Sorry, let me just look at the paragraphs you've mentioned. Just
yes, it's 103 is beginning under the heading DIFC law and the common law, page 27 of 34. That then runs through to before a short discussion of the law of obligations, and at paragraph 106, very, very short in our judgment, having regard to the statutory framework incorporating the torts into the DIFC law by way of judicial decision would amount to impermissible judicial legislation.
Yep, got it. Thank you.
Right, Your Honour, and I'm mindful that I've also got to address the time bar point, which I address in large part in the skeleton, but also in going through the factual issues. The factual issues are at page 1553 to 1555, and there is a bit of duplication between the list of factual issues and the list of legal issues. But just running through, whether the claimant is owed end of service benefits and or other employment related payments by the defendant, we say yes, pursuant to contract and statute. Whether the claimant is owed penalty payments for the late payment, gratuity, etc., we say yes, pursuant to statute. Whether the claimant was an employee within or from the DIFC, plainly an employee, 3 contracts of employment accepted as such by Mr. Aloob, and within or from the DIFC, we say it must relate to a legal base, and you have my submissions in that regard. Whether the claimant was employed by a separate company in Sudan during the relevant period of employment by the defendant, whether this impacts on the claimant's claim. Well, for a specific purpose, and which Mr. MUSAAB described, and as an addendum or in addition to his DIFC contract, yes, he received compensation for a per diem expenditure in Sudan, where he was spending quite some time at the behest of the defendant. Does it impact on the claimant's claim? Certainly not deleteriously. Whether the claimant breached the terms of Agreement 3 by failing to advise the date or failing to advise the reasons, I hear what Your Honour says. My answer to that question would still be yes, but I gather I'm Sisyphus if I take that any further. Whether the claim is time barred, we say no, because there was plainly acknowledgement of debts. We've looked at those. Mr. Aloob has given his evidence. He accepts that all of the documents that I took him through were EXPRESSO documents, and they indicated what EXPRESSO was acknowledging by way of debt. So we say that that cures any time limit, because the event is the acknowledgement as well as the original debt. Whether the claimant owes an amount of 250,000 AED, that in our submission is now put entirely beside the point, because Mr. Aloob was taken expressly to let's see, where is it? He was taken expressly to his second witness statement, which is at page 457. I'll find it in my master bundle. At 457.
Yeah.
That says he was informed of the situation, etc. Upon learning of this, EXPRESSO arranged for the pending cashless amount on the basis that it was deducted from any end of service entitlements due to MUSAAB from Sudatel Group.
Yeah.
Now we say that that's absolutely clear. He was in employment at the time by Sudatel. And it's clear. It's res inter alias acta.
What was I thought the claimant's evidence was that he agreed that this could be deducted from his end of service entitlements in his discussions with EXPRESSO. Have I misunderstood his evidence?
I don't think he went that far. I think what he said was that had they paid him what they accepted was due and owing, then he wouldn't have needed to have called on any payment, because had they paid him 420,000 dirham, he would have been able to satisfy a bail bond of 250,000 dirham.
I agree. He certainly said that. He said if they paid me 429,000, then I wouldn't have had a problem, but they didn't.
Yeah.
And I thought he said expressly that he was agreeable to the sum being set off against any entitlement. Now, if you do the maths, it doesn't really change things in terms of the penalty, as depending, of course, on the size of your other claims. But if there is any sum due and owing, as at the 15th of August 2014, then the penalty payments in themselves, by the date of the 4th of October 2016, have exceeded the 250,000.
Yes, absolutely.
If I've got my calculation correct, and no doubt Mr. Doherty will tell me if I'm wrong.
Yeah, no, that's absolutely right.
So it doesn't stop the penalty running,
but
it would be a sum to be taken into account at the end of the day to come off the figure.
And if Mr. MUSAAB said that, then I can check my notes. I'm not
well,
certain.
I'd be grateful if you would check, but
I will certainly have a look, and if I can shed any light on it, I'm not pushing a contrary position.
No.
I was simply explaining as I understood what his evidence was directed towards. But even if he did say that, and accepting for present purposes that he did, then the answer to your Honour's point is the answer just given. And I think one can go beyond that, because just in round figures, deducting 250 from 420, you're still looking at 170,000 dirham. Yeah. So we're not talking about the accidental incursion of penalties because someone didn't pay 45 fil. You're talking about penalties being incurred because the full amount wasn't, nothing like the full amount was paid, irrespective of the penalties which had clocked up, which in themselves overtopped the amount in question. Did the reverting to the list of issues, whether the claimant attempted to settle the issues with whether the defendant attempted to settle the issues with the claimant? Well, we've gone through that, and we had also Mr. Aloub's evidence as to why it didn't run its full course. Not my client's fault, the group president's fault. Whether the claimant had filed separate proceedings in the courts of Sudan against the defendant to seek the same employment dues. Certainly filed proceedings in the courts of Sudan, but as he explained, and as was clear from the record of the Khartoum Labour Court, although he pleaded the whole relationship, which did start back in 2008, 2009, his claim related to the time after the EXPRESSO employment had ended, and he was very clear about that, and I don't think was effectively challenged in that regard. Legal issues, I hope, can be dealt with very quickly. Whether the claimant was validly terminated for cause, as I said in my skeleton argument, I just don't understand that to be anything resembling an issue which really arises on the present facts. Whether the claimant was employed by a separate company in Sudan whilst being employed by the defendant, and if so, whether such employment places the claimant in breach of the relevant agreement. Plainly not, because insofar as Sudatel was a separate entity, it was only a separate corporate entity. It was, by common agreement, the 100% shareholder of EXPRESSO. EXPRESSO had, on Mr. MUSAAB's evidence, asked him to relocate. He felt constrained to do so because that's what clause 1.2 of his contract of employment said EXPRESSO was entitled to do. He fell in line as a good employee would. So does it make any difference? No, not at all. And was he employed by a separate company? Well, as a matter of strict company law, probably the arrangement was with Sudatel rather than EXPRESSO, yes. But does it make any difference and put him in breach of the first agreement? Certainly not. Was he an employee of the defendant? Yes. And then we have repetition in relation to gratuity and employment-related dues. Yes, he's entitled. Is he entitled to penalty payments? Yes. Was the defendant obliged to advise on the date and reasons? This is the same as point 5, but put in couched in legal terms rather than factual terms. And I agree to differ for present purposes with your honour as to the proper view to be taken in that regard. I hear what you say. And that covers 15 and 16, 17, 18, 19, interest and costs are consequentials which follow the event. I reserve the right to comment on the learned friend's greater elaboration of the law, but unless I can assist you further, those are my submissions for the present.
Yes, thank you very much. Mr. Doherty, what are your plans, so to speak, in terms of how long you anticipate you may need to address me for, subject, of course, to my inevitable interventions?
Yes, of course. I'm probably going to be a little bit of time, to be honest. Part and parcel of that is that obviously went through things pretty quickly yesterday in opening with a view to going through some of those issues in a bit more detail. But I'll obviously, to some extent, be led by Your Honour, moving me on where you have a point. If I feel that there's some additional observations that I need to make, then I'll do that. The way I was proposing to tackle it is to go largely to the issues that you've indicated you're interested in anyway. So what I was going to propose to do, partly because it comes first in sequence, is to deal with the first and second contracts and the time bar issue. I'll then come on to the third contract and the penalties issue. So I'll deal first of all with the base of work argument, then I'll deal with my pleading argument, and then after that what I propose to do is to sweep through the points of contract and points of law that might arise on the heads of claim, and some of those you may not need to hear from me at any great length about, and I'll incorporate into that some submissions that we make on quantum as well.
Right. Well,
so that's what I'm proposing to do in terms of order of play. I
yes.
hope that this will cover off the issues that you had identified that you're particularly interested in doing that.
Okay. Well, why don't we go for 3/4 of an hour and then take a 10-minute break or something at that point, which would be a convenient point for Mr. Patrick Joyce to eat the sandwich that he bought half an hour ago, or 1 hour ago.
I'm obliged, Your Honour. Well,
I could do with a sandwich myself at that point. So let's go for about 3/4 of an hour, and I'll indicate to you where I think you can hurry on. Start where you wish to start, and I'll tell you what I need to hear you on.
Yes, thank you, Your Honour. Okay, so as I indicated, first I'll deal with the claims under the first and second contract and the overarching points rather than dealing with the minutiae of the individual claims.
Well, I can help you there. As I understand the argument on time bar for agreements 1 and 2, Mr. Patrick Joyce is dependent upon acknowledgement of debt.
Yes.
And you say there's simply no provision for that in the DIFC framework of law. There's no section 29 of the Limitation Act equivalent in the DIFC law. That's the first point you make. And
yes.
if that's right, that's the end of the point. I don't need to hear you on that point, but if you're wrong on that, I mean, it's not capable of elaboration in any event, is it really? I mean, that's the beginning and end of it.
Yes, I suppose the only additional point to that is whether you're going to be helped at all by looking at the relevant bits of TIG. I drew your attention to them yesterday, so it may well be that you've already had a look, but it's 109
I don't need TIG for that proposition. It's a fundamental point that is made clearly in TIG, but it's there regardless.
Yes,
but the only other point that, if you're right on that point, then of course it doesn't matter at all. But if you're wrong on that point, the evidence that came out this morning in relation to the exchanges upon which Mr. Patrick Joyce relies was, to my mind, rather odd. But essentially what I understood the witness to be saying this morning was that actually all of this was part of a process of negotiation. And when he, at the end of the day, said that his own view was that the defendant ought to pay and simply pay what they thought was indisputably owing, that wasn't represented by the figures that appeared in the final settlement accounts, which were concessions on his part for the purpose of negotiation in order to achieve a deal with the claimant. So the question that I would have, if it matters, is whether or not those are truly acknowledgements of debt for the full sums in question, if they are being put forward as offers of settlement.
Yes, quite right, Your Honour. Just before I do address you on that, the only point I just want to put a stamp on is to say that the same arguments on the applicability of the Limitation Act and the DIFC we rely on in this context, but also when it comes to Section 35, just so I don't have to come back to this issue later. And Section 35 of the Limitation Act, which deals with out-of-time amendments and when they are deemed under UK legislation to take effect.
No, I've got that point entirely, yes.
So it's the same argument, it just applies in a slightly different context on a slightly different head of laws. But yes, quite right.
We will need to explore that in a bit more detail in the context of claims being made and so on and so forth. But I understand that point.
Yes. But yes, you're quite right. The points that I had minded to bring you to were to say that even if one were to form a view that there is a route to get into there being this same provision by acknowledgement of debt in DIFC law, of course we dispute, but there are problems with that analysis on the facts for precisely the reason you raised, because the documents that Mr. Alud was taken to earlier all say at the top, final settlement. And that's precisely what he described it as being in his oral evidence. It's an exchange, it's a negotiation, it is an attempt to come to a finally settled position on entitlements. Yeah. And coming to a settled position on entitlements is different to agreeing to a specific debt being owed, in the same way that one undertaking attempts to settle a claim before a court is not an acknowledgement of debt, which resets the limitation provisions. And my submission, that would be an absurd conclusion. But beyond that, there are also probably questions about the facts or the debts that the statements themselves are purporting to settle, because they seem to cover both elements of his pseudo-TEL entitlements and his EXPRESSO entitlements. And so that might also bring in questions of, on the one hand, who's actually agreeing or acknowledging this debt, and on whose behalf is it acknowledged? That might bring in to question issues of authority about the people supposedly making the acknowledgement, particularly given that my learned friend's own submission, or the issue that he went to during cross-examination of Mr. Alud, was the fact that ultimately when this comes to the group president, he's saying that the amounts weren't approved.
Yeah.
So if at the highest level it's not being approved, then at the highest level it's not being acknowledged. So that disposes of the point as well, we would say.
Yep. All right.
And so what that brings you in terms of the first and second claims is Mr. MUSAAB accepts during cross-examination that his entitlements to salary and payments fell monthly in arrears. I don't need me to go through each of those heads of loss and indicate why we say they're out of time. But obviously, if he's due to be paid his salary entitlements monthly and they're not paid monthly, the point in time at which limitation starts to run is the monthly in arrears. So those claims are out of time. When it comes to the payments he says were due on termination, again, during cross-examination, the claimant accepted that those sums were due and payable within 7 days of his contract being terminated. So for the first contract, that comes to an end either in September 2009, if you follow the defendant's arguments, because he becomes a pseudo-TEL employee, but even in his best case, he gets to August 2010. So the entitlements to termination benefits that would crystallise then are out of time relative to when this claim was presented. And the same point applies with respect to the second contract, because it terminates in 2012 and the claim isn't brought within the limitation period. So that defeats, in effect, the entirety of those claims. I don't know whether my learned friend would argue that he has a get out for this in saying that there's a continuous term of employment. I don't know if this is an appropriate juncture to address Your Honour on that, but we have a couple of points to make. First of all, when it comes to the first contract, there's no linkage, as a matter of fact, between the first and second contract, because on the facts, we say he enters into the pseudo-TEL agreement in September 2009, he, without complaint, receives payments under the consultancy agreement from that date. And so the proper analysis is that his first contract terminates in September 2009, and any employment period that he could have had with EXPRESSO after that can only resume from 2010. So the best possible case from his perspective is he gets a continuous period from 2010 through to 2014. But in quantum terms, as I think Your Honour observed yesterday, that doesn't actually get you anything different when it comes to calculating your end of service gratuity, because you're not going to then get over the 5-year threshold, which gives you the bump from 21 days up to 30 days.
Yes. So this is a slightly different argument from the argument you put in relation to simply saying that for each agreement 1, 2, and 3, you calculate the end of service gratuity independently by reference to each contract. This argument depends on saying there's a break in continuity because of the existence of the consultancy agreement.
Yes, so I suppose the way of framing is that we do say that there's a break between each of them, because that's the effect of the expiration of a fixed term as a matter of law. I can come on to that point in the statutory provisions, but you referred to them earlier. If you look at the statutory provisions on the effective date of termination, what that says is that if you have a fixed term contract, it terminates on the date that the contract says it does. And the response to that my learned friend raised is to rely on the Fernando, not Fernando, small claims tribunal case.
Yeah.
A couple of points to observe about that. First of all, it's not binding on this court anyway. But I think more saliently, it's contemplating a different set of circumstances entirely. And if I can perhaps just take you to that very briefly, it's at 1482. And the extract that my learned friend relies on, paragraph 3, entered into contract for the period of 1 year, February 13 to 14. The claimant and the defendant, upon the expiry of the contract, agreed to renew it for 1 more year to 2015, the change in the basic salary, but with the same terms as the first contract signed between the parties. And then when we get the second renewal, it says the same thing. The parties again renewed the contract with the same terms with a difference in salary. So on the expiry, or indeed prior to the expiry of the fixed term in that case, what's happening is the contracts are being renewed upon the same terms as the first contract that was signed by the parties. But that isn't what's happening here. So, for example, there's no documentation anywhere which suggests that there was a reaching out to the claimant and saying, we're going to renew your contract, or the defendant writing to the claimant saying, we'd like to renew you on the same terms as previously. Here's an addendum updating your salary, but all of your other terms and conditions will remain the same. Instead, what happens as a matter of law, we say is clear if one looks at the relevant provisions of the agreement. So Your Honour will have looked at it already. It's at page 890 if you do want to go there. But this the contract terms clause 3.
Yeah.
So employment will commence, this is the third contract, 1st of August, and shall continue until 31st of July 2014, unless terminated pursuant to clause 13.
Yeah.
3.2, your employment is for a fixed term and finishing on the date specified in clause 3.1, unless you resign or the company terminates prematurely. And then 3.3 is an important provision which says that nothing here should be read as providing you to an entitlement or expectation of further employment beyond the end of that date. So as a matter of contract, this is an agreement which terminates automatically unless it's terminated prior to that. And so each time the termination takes effect, what happens in fact is the parties negotiate and they enter into 2 distinct separate contracts with fresh fixed terms. So it's not a renewal upon previously agreed terms as you find in Fernando. There's no renewal at all. What happens here, as a matter of contract, is automatic termination, which means that the contract comes to an end. And that contractual provision is supported by what the definition of effective date of termination says in the employment law. And I think that you have that point. It's at page 1315 if you want to look at it again. But it says, in relation to an employee who is employed under a contract for a fixed term, which expires without being renewed under the same contract, means the date on which the term expires. So that language is, we say, actually quite important, because renewal, in that definition of effective date of termination, says being renewed under the same contract. And perhaps it would assist you on to look at that. It's a 1315.
Yeah, thank you.
And it's the middle of the page. It's point C under effective date of termination. So that's the critical distinction really here between this case and what seems to be being described by the Small Claims Tribunal in the Fernando case. Because in that case, the renewal was upon the first contract on each occasion. And that's what the legislation says. Term which expires without being renewed under the same contract. And when that happens, you get termination on the date stated on the fixed term contract. And on the facts here, there's no renewal. You enter into a succession of contracts. And so those contracts, as a matter of law, take effect as separate agreements and on separate terms, rather than being continuous.
I've just lost the provision of in relation to fixed term contracts. Where does that come in?
1315, middle of the page, under effective date of termination. This is in the 2012 law, but it's in the 2005 law. You can see as well, because there's no black line striking it out. In point C, so it says in relation to an employee. Yeah.
Yes.
Three of the words we emphasize is under the same contract.
I mean, that is so. Under the same contract would literally mean same terms and conditions, same salary, same everything.
I mean, I suppose one could see that it would be a matter for argument. So, for example, if you had a case where you have one contract of employment for a year, let's say you then have a provision in that saying this may be renewed at the discretion of employer for a further period and such terms as we see fit. And then you have, say, an email or some kind of addendum agreement saying your salary will be X. So an increase in salary, you may well say that it's exactly the same, but you could extend a contract in that way and argue that it's the same contract. So what you would be dealing with in those circumstances is the core terms and conditions as amended by an addendum which renewed the contract. But I suppose even if that argument was open to an employee seeking to invoke this law, that's not the factual territory that we're in this case, because we don't have a renewal of the same contract. we have separate contracts in each occasion.
So that looking at the terms of 3.4 little c and the provision that at the end of the fixed term, the company will either tell you you're coming to an end or negotiate an extension. You say an extension would or would not be renewal under the same contract.
Well, an extension in that context would mean an extension to the current contract. So what one would expect to see, I think, if there was an extension, is an addendum agreement or something like that, saying we refer to your contract of employment dated 1st of August 2010. We renew this for a further period expiring on X date. So that's
that would require exactly the same terms, other than period of time. No change in salary, no change in position, no promotion.
I suppose it would depend what you were trying to achieve, because of course one can vary the terms of a contract, yeah, as long as you go through the mechanism that the contract stipulates for how you vary that. So if it's an agreement signed in agreement in writing signed and so on, yeah, I suppose that one would take the view that it is theoretically possible to change the salary. I think really the fundamental point here is that that's not what's happening. What's happening is we have a succession of contracts where his job title changes, where salary changes, where actually it's not just changing the figures, but it's also changing the basis and some of the entitlements that have been offered. So some contracts offer relocation, some don't. Some have provisions that are different in relation to education alliances and things like this. So they're clearly freshly negotiated instruments, and on their face, they are stated to be freshly negotiated and executed instruments because they bear a new date, they bear a new job title, they're executed again by both parties when they're signed, and so they're clearly on this analysis not the same contract.
Yes, this is a more difficult point than I had first supposed, I think. Can we have another look at what Judge Nasser said in the Small Claims Tribunal and the reasons that he came to the view that he did? I mean, I'm putting my cards on the table, Mr. Doherty. If you think about this in the context of similar employment provisions elsewhere, and I appreciate that we're construing statutes here and so on, but if you think about the policy that underlies the end of service gratuity, for example, one's looking at what might be thought of as a redundancy payment or whatever. You're giving the employee something to tide him over in respect of his past periods of service. And so to restrict that in some way by fixed term contracts of employment does seem extremely odd. If you've had a continuous period, and let's assume for these purposes we are talking about a continuous period of either 4 or 5.5 years, as the case may be, you would expect to look at all that in the context of years of service and so on, as the statute provides, without regard to the particular terms of the contract in question. And so this question about renewal or same contract
well, just bear with me, Ron. I'm just looking up to let you know what I was doing, what I was trying to look up was the equivalent provisions in the 2019 law to see whether or not this is in fact a largely academic question from the DRC's perspective, and whether it's something that they've looked at for. I mean, the fundamental submission, of course, from our perspective, is that the terms in which the 2012 and 2005 employment law are drafted are clear, and so ought to be applied in the same way that the court has in the past applied provisions of those laws which, in retrospect, the legislature has thought seemed harsh, but nevertheless had to be applied in strict terms. It's at 1398.
Thank you.
It says, in relation to an employment contract concluded for a fixed term, the effective date of termination expires on the, well, it's on the date that the term expires. So what we appear to have lost there is this reference to being renewed under the same contract. So insofar as those words were seen to have given rise to a potential problem, particularly in end-of-service gratuity regimes, which have been changing in the DRC in recent years, in terms of post-termination protection of employees, one could assume that the words would have been removed potentially for a reason, but in the context of this dispute, they still apply. So one would assume that the current position in law is that if you've got a contract for a fixed term, it expires on the date the term expires. And what one would then expect is that the term could be extended by further contractual arrangements.
Yes. Can we just look at Judge Nasser's reasoning again? Page?
It's at page 1482, paragraph 3. This paragraph 3 sets out the factual circumstances to enter into contract of employment.
And then the reason discussion is 10 and 11, 12.
Yes, and so what he says in paragraph 10 is he explains the terms of the contract, the fact that the original contract contains a clause saying that the parties upon their agreement have the right to renew. The claimant, the defendant, upon the expiry of the contract, agreed to renew for 1 year, so that's pursuant to the term in the first contract. Yeah. And what there was a slight change in basic salary, but with the same terms of the first contract signed between the parties. Later, upon the expiry of the second contract, the parties renewed the contract for 1 more year, again with the same terms, but with a difference in salary and monthly allowance. Therefore, the contract continued with the same terms for 3 years, but with a change in the salary and monthly allowance. I'm satisfied to consider 3 employment contracts as 1 contract starting 2013, ending in 2016. So it's 1 contract extended pursuant to the terms of that contract.
Yeah.
Which would fall within, of course, you're not bound by the SCT, but it would fall within the legislation.
Let me just explore what the effect, if you're right, on this is.
Well, there's potentially a somewhat counterintuitive point to this, in that what my learned friend argues for in a continuous period of employment, in fact, when one looks at the consequences of that, might actually be to reduce whatever the claimant's claimed entitlement is. So the starting point is that when it comes to end of service gratuity, given the break in the first contract when the pseudotel employment happens, the best case scenario we say that the claimant can get to is continuous employment from 2010 through to 2014. In quantum terms, it doesn't make a difference, because if you've got two fixed term contracts, you've gone over the 1 year threshold that entitles you to end of service gratuity, and then you get your 2 years allowance at 21 days each. So all you're doing is having two sets of 2 rather than one of 4. But the number of days you're entitled to is the same. The significance in this context is limitation, really.
Yeah, exactly. That's the point. I mean, if one looks at each of these 3 contracts separately, then there's time bar.
Yes.
On your case for contracts 1 and 2, and you're simply left with contract 3 and an end of service gratuity related by reference to a period of 2 years.
By reference to the third contract, yes. So it's relevant to the limitation provisions. The reason I say that there is a counterintuitive element to this is when one considers what a continuous contract would mean when it comes to the claims for annual leave. And we've looked at the terms there. I can go through them in detail, but in effect, if you've got a provision in the contract, which we say there is, which means that you accrue over the course of a year, 1 year's entitlement to leave, and the contract says that if you don't use that entitlement, it expires, and you can't have entitlement to payment in lieu. If you're looking at a 6-year continuous contract, the only potential entitlement you would have to payment in lieu relates to the year immediately prior to the date in which you're terminated. So in this case, if you worked it through, if the claimant started his employment in 2008, by the time he gets to 2009, he's lost his 08 allowance. By the time he gets to 10, he's lost his 09 allowance. By the time he gets to 11, he's lost his 10 allowance, and so on. So when you actually look at the position at the point in time of his termination, what is his potential entitlement to accrued but unused leave? The answer would be only what was left in the final leave year, which if you work forward, the date on which he commenced employment through to the date on which it's finally terminated would only be 9 months, because it would go November 08 through to August 14. So in his final leave year, the only entitlement he has accrued is the 9 months up to the point in time he's terminated in August. Whereas if one was to view this as a series of broken down individual contracts, that position might actually counterintuitively be different, because you might have an arguable entitlement to the last year of each of the 3 successive contracts. So what we would say about that is that the claimant obviously can't have it both ways. He can't have a continuous contract for the purposes of calculating his end of service gratuity, but have non-continuous contracts which entitle him to additional amounts of annual leave. And so even if we get there, of course, because there are a host of issues in liability before this, but if the claimant is right about his argument of continuous contract, where it potentially leads to an increased quantum when it comes to end of service gratuity, it actually reduces quantum on annual leave.
Yeah.
I hope I've explained that clearly. Hopefully that should make some sense on where this argument actually gets us.
So what's your best case on end of service gratuity?
Well, our case on end of service gratuity is that claims 1 and 2 are out of time.
Yeah.
Claim 3 is not an entitlement because the employment law doesn't apply.
Well, I understand that, but supposing I'm against you on the application of the employment law, and that this is an employment contract, and for whatever reason, Article 4 doesn't rule out the application of the employment law. Supposing I'm against you on that, your case is simply that the end of service gratuity falls to be calculated on the basis of the 21-day entitlement.
That would be the
Right.
position of Quantum. I think the pleaded position is that we would say that his end of service gratuity entitlement for this period is actually, as he has put before the Labour Courts in Part 2, something he's claiming from Sudatel. That was the document that we went to during cross-examination that shows that his end of service gratuity claim in Sudan was for multitudes of entitlement greater than what he would have been entitled to for employment just from 2014 to 2017.
Well, it didn't fit from 2008 to 2017 either. On your case, it was 11 months worth, which doesn't equate. He explained that on the basis that there's a multiple plan of 4 times the monthly amount, which gave rise to 11 months worth. But it wouldn't fit from 2008 to 2017, which was what his period of employment was, as alleged in cartoon. So it didn't, that didn't really seem to me to assist. But the bottom line would be, if I was looking at simply agreement 3.
On a figures basis, I think what we'd be saying is it's because you've only got 2 years, it's the 21 days.
Yes. Yeah. Okay. I understand the point.
Before moving on to the arguments about base of work and penalties provisions more generally, which really I think is where a substantial amount of the issue in this dispute really lies.
Well, it's where the money lies, yeah.
Yeah, it's obvious that one would spend time dealing with those issues. This is a connected point, but really it's just to be clear about what the position is under claims for the first and second contract. Now, if Your Honour could turn up page 1192. Which is part 3 of the 2005 law before it was amended in 2012.
Yeah.
We can see that the relevant provision here really is Article 16. An employer should pay all wages owing to employee within 7 days after the employer or employee terminates the employment. That's it. So there's no Article 18.2 regime under the 2005 law.
Yeah.
And I can take you to the enactment notice if you like. It's on page 1320. But the 2012 amendments come into force in December 2012.
Yeah.
So that's post the expiry of both the first and the second contract. Yeah. So the penalties regime doesn't come into existence at the time the first and second contracts have come to an end, at which point, whatever way one analyses it, entitlement to payment would have to crystallise. And the court has already looked at the question of retrospective effect of the 2012 amendments. It's the case I've cited in my skeleton, but it's McDuff and KDH. It's a page 1468. And is Your Honour got that?
Slowly, but it's coming. It's coming. Yeah, I've got it.
The reasoning begins at paragraph 39 and continues down to the bottom of that page to 43, which you might want to take for your note, but really the conclusion is at paragraph 44. So the signing of the agreement, the resignation, the termination, and the proceedings before the court all commenced before the 2012 law came into force on 23rd of December 12, and therefore the new law cannot be applied to the dispute retrospectively. Therefore, the old employment law i.e. the 2005 laws, to remain the applicable law in the context of this dispute. So really that point is highlighted simply to say that if you were to find that there was some in-time sum owing under either the first or the second contract, no penalties can latch on to those entitlements because the penalties regime didn't exist at the time and can't be applied retrospectively.
Let me just read these paragraphs. Whose decision is this? Court of Appeal, is it?
I think this Court of First Instance, it's Court of First Instance as Justice Al-Madani on the 13th of February 2014.
Yeah, okay.
And in many ways, it doesn't really say anything much different to what we know from TIG, albeit in the context of new law.
I'm just trying to get the exact timing right there on this one. Yeah. Yes, okay.
Your Honour, the next issues that I'm going to come on to all deal with the applicability of the penalties regime. You indicated that I may be wrong for 45 minutes and then we take a short break. So I don't know if before we start getting on to those issues, you want to take that break shortly now.
Probably, if you're going to be any significant period of time.
Yes, as I indicated, it's where the money is, and it's unsurprisingly going to occupy a bit of time from my perspective.
Broadly speaking, and without commitment, how long would you expect to be?
Probably an hour. We can try and be less, but I think that's roughly where I'd say that would be on closing submissions at 1 hour 45.
Okay, well, let's should we take quarter of an hour now and begin at well, my watch says that would be 10 past, but I'm probably a bit slow. But let's aim for 10 past the hour.
Thank you.
I would like, Your Honour.
Okay, thank you very much. Yes, Mr. Doherty, is Mr. Patrick Joyce there in sub silentio? Yes.
I am, Your Honour.
Thank you. All right, on you go then, please, Mr. Doherty.
Thank you, Your Honour. The next issue I propose to address, in some respects, is the elephant in the room. And I say that because it's the argument concerning base of work, which my learned friend really, in my submission, doesn't seem to address, nor did it really come out of any of the evidence.
I can't see you, Mr. Doherty.
My camera's on. I'll turn it off and on again.
Can you try again? Yes.
Of course.
That's good. Thank you.
Perfect. The argument arises from Article 4 of the 2012 law, which, because it's important, I'm aware that you're all will be familiar with it, but I think we probably need to turn it up. Page 1273.
Yes.
Which says the law, i.e. the employment law, applies to an employee of an establishment having a place of business within the DIFC or an entity that is created by law number 9 of 2004, comma, and the employee is based within or ordinarily works within or from the DIFC. Then subsection 2 is the applicable law to contract for employment of an employee based within or who ordinarily works from the DIFC shall be this law. There are obviously two aspects to that. First is you have to have a DIFC establishment or a business or a place of business within the DIFC. But importantly, there's an additional requirement, noting the use of the word and, not or, that the employee is also based within or ordinarily works within or from the DIFC. So an argument that simply says, well, you've got an entity, it's registered in the DIFC, doesn't get you there because you have to show that the second part of the scoping provision applies, which is DIFC establishment plus employee working within the DIFC. And to be clear, as an extension of that point, the judicial authority law isn't an answer because this isn't a question of jurisdiction, it's a question of territorial scope of the law. So to give the example of how this would work, if the claimant is not covered by the employment law, it may well be that he has a rump of contractual rights set out in his contract, and it may be that the contract law then applies to him. So it would still be within the jurisdiction of the DIFC. It's just that this specific provision related to employees doesn't apply.
Can I just stop you for a moment? For 41B, entity that's created by law number 9, law number 9 simply the corporate law, is it?
Yeah, so I believe so. So I think it would be a DIFC entity. I'll double check before you say I don't want to.
Well,
that's the numbering off the top of my head.
No, all right, but place of business within the DIFC for A gives rise to the same, or at least a potential argument, alongside employee based within or ordinarily works from or within or from the DIFC in this rather odd situation where the office is actually outside the DIFC.
Yes, well, just to be clear, the issue here, we're not saying that the defendant isn't a DIFC entity. That's not where this issue arises.
No, it's a registered. Absolutely. Yes, that's why I asked whether it was covered by law number 9.
Yes, so that aspect's not in dispute. So 1A and B are not the disputed issue. The disputed issue is that you have to have A or B, and you have to have the final part of the provision about which is the territorial scope of the law is defined by reference to the employee as well, not just the employer. So you can't just say DIFC entity, therefore it applies. That's not good enough. And to better understand the scope of that provision, what one can also do is look at the position now under the 2019 law. So if you go to 1363, it's at the bottom of 1363. Which then continues into the top of 1364. But it's subject to Article 4.3. This law applies to, so we've got the same point, A business in the DIFC, so that's not the issue. And then B, we have an expansion. So an individual employed by way of an employment contract who is based within or ordinarily works from the DIFC, or under the new law, you can have agreed in your employment contract to be the subject of this law. Or we have provisions that you're working under, so subsections 2 deals with secondees. So by the time we get to the 2019 law, we're looking at a much wider application, which includes those specific provisions about how you treat secondees, but also allows parties to contract in to the application of the DIFC employment law, which clearly, given that that's been an inclusion, is something that you can't do under the old law. So what appeared to be an argument by my learned friend that one can go to the contract and look at the governing law provision and see in that some option that the employment law should apply, that argument doesn't work, because under the 2005 law, as amended in 12, you can't contract into the employment law. The only way for Article 4.1 to apply is if you, as the employee, can show that you work within or from.
Yeah.
So then, to come back to the 2005 as amended definition, to break it down a little bit. So you have to be based within or ordinarily work within or from the DIFC. So just working out what's meant by those words, worked within the DIFC, I think is probably pretty obvious. It means that you're ordinarily working within the geographical confines of the DIFC.
Yes.
From, I mean, one could inquire as to whether the word from actually adds much to the word within. At first glance, perhaps not, but one could perhaps see there being a distinction when, for example, you have someone who's working ordinarily out of a DIFC office, but that their job is out and about, if I can put it that way. So you set up in the morning in your office and then you're working elsewhere. So for example, let's say you're employed as a driver for a DIFC business with its place of business in the DIFC. Your job might be starting at the office and driving other employees to meetings in Abu Dhabi or elsewhere and onshore Dubai and so on. And there you might say that you're working from the DIFC, even though you might spend actually most of your time outside its geographical confines, at least so you can escape the traffic, obviously. So that would be potentially the distinction between within and from. And the final way that the law applies is if you're based in the DIFC. And so to think about what sorts of things could well be covered by that, things potentially like management consultants, you work for a top 4 firm, something like that. You have your DIFC office, it's where you're based, it's where your line managers are, but often you might be shipped out to a firm somewhere else working out of a client office, whether it's onshore, internationally, etc. So one could see that your base in those circumstances would be the DIFC, even if you're spending time working in client offices and so on. Your Honour might have noted when you read my skeleton that I provided some English case law on what base can mean. Obviously, you have to some extent, take that with a pinch of salt because we're dealing with a different statutory framework, which is the Employment Rights Act, which at the time of this particular judgment didn't have territoriality provisions, albeit that it used to. I think there used to be provisions that said you're working within Great Britain. But this is the Lawrence and Serco case before the House of Lords. The context is considering the application of the unfair dismissal regime that exists under the UK Employment Rights Act to peripatetic employees, so people who are on the move. And the relevant parts of that judgment start at page 1431. So first of all, at paragraph 28, there's a discussion of a case which arose under older statutory provisions, Crofts and Vita Limited, talking about the concept of employment in Great Britain not being easy to apply to peripatetic employees. And if you go to the final sentence of paragraph 28, it says that the solution adopted under the old ordinarily works outside Great Britain formula was to ask where the employee was based. And then it refers to an extract from another case called Wilson's case, where the test that was applied at that time says, in such a case, it appears to us that the correct approach is to look at the terms of the contract, express and implied. It continues for the limited purpose, which in order to ascertain where, looking at the whole period contemplated by the contract, the employee's base is to be. It is in the absence of special factors leading to a contrary conclusion, the country where his base is likely to be is the place where he is to be treated as ordinarily working under his contract of employment. Where his base under the contract is to be will depend on the examination of relevant contractual terms. These will likely include terms such as expressly define his headquarters or which indicate
where the travels involved in his employment begin and end, where his private residence, his home is, or it's expected to be, currency paid and so on. So looking at a myriad of factors. And when we come on to paragraph 29, the House of Lords looks at a slightly different approach. Judgment reads, I think that we are today more concerned with how the contract was in fact being operated at the time of the dismissal rather than the terms of the original contract. But the common sense of treating the base of a peripatetic employee as, for the purposes of the statute, his place of employment remains valid. It was applied by the Court of Appeal to an airline pilot in Toll versus British Midland Airways. And then it's an extract from a Lord Denning judgment. A man's base is the place where he should be regarded as ordinarily working. Even though he may spend days, weeks, or months working overseas, I would only make this suggestion. I would not think that the terms of the contract help much in these cases. As a rule, there's no term in the contract about exactly where he is to work. You have to go by the conduct of the parties and the way they've been operating under the contract. You have to find at the material time where the man is based. And in paragraph 30, the judgment says that Lord Denning's judgment there provides the most helpful guidance. So in effect, the approach of the English courts is to ask, how is the contract being operated in terms of where the individual should be considered to be ordinarily working? But what we can see, I think, from the older case law is that when one is looking at all the circumstances, other factors that can be relevant are what the contractual provisions say, the nature of the travel undertaken. Really, it's a non-exhaustive approach, and one which is said to be, in some respects, a question of common sense. Now, of course, that's not necessarily directly applicable in the DIFC, but one can see there being a degree of sense in looking at the reality. And here we say there are a multitude of factors that point incontrovertibly away from a DIFC base of employment. First of all, we went through the nature of the claimant's work in evidence yesterday. It was a role that required him to be involved in operational matters, meetings with partners and so on, rather than what one might expect to be a back office function or a head office function that you would carry out, say, if you were in finance or an audit or something like that. The second point is that the claimant's base, in the sense of the place he was ordinarily working, is clearly Sudan. As Your Honour pointed out earlier, he identified under all three contracts his home as being Sudan. We went through in some length the travel records, which shows that he's spending very few working weeks in Dubai. So in the sample we looked at, spanning around 40 weeks, sorry, what we find is that he's spending weeks in a time in Khartoum, occasionally reverting to Dubai for the weekends, so non-working days, and remembering that the question is, where is he ordinarily working? But in the weeks that he may well be working in Dubai, that's around 5 out of the 40 odd weeks that we looked at, so a very small amount of time. And indeed, much of the time he appears, as I say, to spend in Dubai is either not working time, as I say, because it's a weekend, but it's also when he's transiting. So it's flying through Dubai, an international hub as it is, from an original point in Khartoum to other places where he's required to work. So we've seen that on a couple of occasions in the trips that he took in 2014. So he starts in Khartoum in Sudan as the origin point. He goes on trips to Lisbon and Rome, and on both occasions he returns back to Khartoum. And over the whole of that period, by far, the place that he spends most of his time, the place that he bases himself, is Khartoum. And it's not just during working weeks, it's for stints of weeks at a time. So there are repeated instances of stints of 2 to 3 weeks. There are stints of 1 of 7 weeks. Perhaps the most striking is that from the 10th of May through to the 31st of July, he's in Khartoum the entire time, with the one exception of when he takes a return flight to Rome and back. Third, what we also know is that for almost the entirety of this relevant period, so that's from 2008, November 2008, through until March 2013, the claimant doesn't even have a residency visa for the UAE. And he accepted during cross-examination that he never spent more than 30 days there. Something which we say is in stark contrast to the protracted periods of weeks and months at a time that he appears to be spending in Khartoum. Fourth, again during cross-examination, he acknowledged that he was a member of the group's executive team, which he acknowledged was based in Khartoum. And in my submission, a senior employee of the group reporting directly to the CEO, there obviously would have been an expectation that he would be based where the rest of the executive management team are. So that's Sudan, not in the UAE. And fifth, and really, even if you ignore everything that I've just said, this is the crucial point, is that the claimant's own evidence about his office, about where he says he kept some of his files, wasn't an office in the DIFC. There's another free zone, it's in JLT. And Your Honour will recall that the claimant accepted during cross-examination that each of his contracts in referring to the Dubai office referred to the JLT office. And he himself, unprompted, during the course of his oral evidence, referred to the fact that his business cards provided his address where he was. And we went to those business cards. They were the cards produced for the first contract and for the third contract, and both of them contained the JLT address. What Your Honour hasn't heard at any point or seen any documentary evidence is that the claimant was ever, on his own evidence, working out of the DIFC office, or for that matter, that he set foot in the DIFC. So when one looks at that, in the witness evidence, the answers given in cross-examination, the documentary evidence, there's not one piece of material before the court that shows that the claimant was ordinarily working from the DIFC. And in fact, we have quite a body of evidence to the contrary. And that, we say, ultimately is fatal to his claim for entitlements under the employment law. Because if he's not based within the DIFC, and he's not working within the DIFC, and he's not working from the DIFC, the employment law simply doesn't apply. So the best that he can get to on his claim is an alleged contractual entitlement to various benefits. But the critical factor there is, of course, that if he's got a contractual claim, he doesn't have a penalties claim, because penalties arise by operation of statutes, and in this case, it's statutory provisions that don't apply.
Well, he also doesn't have an end of service gratuity claim, does he either?
I mean, I'm not going to make his friend's case for him. Our submission is no, he doesn't, because end of service gratuity is an entitlement that arises under the employment law. I suppose one.
Well, it's clause 12.1, isn't it, in agreement?
Yes. So one, I suppose, could put forward an argument that you have a contractual right to like gratuity.
Well, I need you to addressed me on clause 12.1, which says on termination of employment, he'll be entitled to an end of service gratuity, quote, according to the applicable employment law, close quote. Well, the logic of your argument that the DIFC employment law doesn't apply is that that is not the applicable employment law, and the relevant applicable law would presumably be that of Sudan.
Yes.
So you'd be then in a position of an oddity, wouldn't you, where there is an express incorporation of DIFC law as the governing law in clause 19, and because the ambit of Article 4 is not sufficient to include him, clause 12.1 doesn't give rise to an entitlement under DIFC law, but might arguably give entitlement under some other law, for example, Sudan.
Yes, it may well do. So I think that the best way to look at that provision wouldn't be that another employment law applies or that another social security provision applies. I think the correct analysis is that what you would say is that Mr. MUSAAB has a contractual right to end of service gratuity, which is defined by reference to the extent of an entitlement that might be available under a particular law. And I think at that point, you're really getting into an argument about the proper construction of the words applicable employment law.
Yeah.
So he might have a contractual right to the equivalent of, again, it's a matter of construction, Sudanese end of service gratuity on the one hand, or DIFC end of service gratuity on the other hand.
Well, let's be quite clear what you're arguing for, Mr. Doherty. Are you saying that contractually he gets into the end of service provisions of the DIFC law or not?
Well, we say that he doesn't because he's claiming those, or on our case, he's claiming those in Sudan, which suggests that his contractual right is in Sudan. I suppose what I'm conscious to avoid is any suggestion that by this provision he could have somehow contracted himself into the employment law, which of course at this stage he can't. That's a creation that comes subsequently in 2019. It's not part of the provisions.
I understand that point.
So I really, the reason I'm sort of moving around is because I think it's probably a point for Mr. Pratchett-Joyce to argue whether he thinks that his fallback position is that there's a contractual right to like benefits under the DIFC employment law. I think I would go so far as to accept that there's an argument that he would have a contractual right based on that provision alone to some form of end of service gratuity, but ultimately,
well, the logic.
Or we could fall on that line just to say it's Sudan because that's where he's based.
Yes, and this is where the Sudan contract presents a problem. Assume that I'm against you on the consultancy issue and that there is an employment contract here. We are in a position where there are two employment contracts, which both contain terms as to, for example, vacation, holiday leave. And there's not the slightest chance of me working out how those two provisions interrelate. Is he intended to get 35 days leave under the Sudan contract at the same time as having his 24 days under the DIFC, under agreement, let's not say DIFC, under agreements 1, 2, or 3, or whatever it may be?
Yes.
The idea he could possibly be getting 59 days of holiday entitlement altogether, because he is entitled to both, is so uncommercial as to rule it out effectively. But how on earth one's intended to read those contracts together is problematic. And the reality of the position, as I understood it from Mr. Aloub's evidence, was this was a complete shambles. They simply didn't work together. The Sudanese bit of Sudatel on the one hand, and the HR bit of EXPRESSO on the other. And so you have two contracts which are overlapping at least.
Yes,
in relation to what is to be done.
Yes, well, I suppose the 2 points we would say there is that it does appear to be uncommercial, but that's why we would invite the court to accept the view that's put forward in relation to the consultancy.
Well, I understand. I understand that.
But I think the fallback on the particular heads of laws, the holiday, vacation, etc. Our answer to that is, to some extent, to say that the problem isn't engaged, because even if you assume that the provisions of the DIFC contracts applied, they're use it or lose it entitlements. So the fact, I
understand that his evidence was that whatever his holiday entitlement was, he didn't take it.
Yes.
Under either contract.
Yes. So to some extent, I realise that's ducking the question to some point, but I think the answer we give to that is to say we can duck the question because there's another answer.
Yes, well, there's an answer on either foot, but the court will probably have to duck the question at the end of the day. But there we are.
But really, ultimately, and really, like I say, this is the elephant in the room, because it hasn't really been properly addressed by the other side. Is that when one looks at the reality of this situation, when one asks, looking at all of the facts, applying a common sense approach, where is Mr. MUSAAB based? And we haven't heard or seen one piece of evidence to say that, well, I was working 5 days a week in the DIFC office and that's where I was based. We're not in that territory at all. And really circle back to one of the points I made in opening, what the application of Article 18.2 under the old law requires the court to do is to take a provision that has been repeatedly acknowledged by both the courts and at least by implication by the legislature to be at times unjust or unfair provisions once strictly applied. And if the claimant is coming to this court seeking the strict application of that draconian regime, then that cuts both ways. And if one goes to the regime and looks at the strict provisions as to how it should apply and over what territory it should apply to employees, the clear answer is that if you're not based within or working within the DIFC, then you don't get those statutory protections. And so the penalty claim has to fall away for that reason.
Yeah.
So, Your Honour, unless I can assist you further on that particular point, what I was proposing to do is to go to what we say about this time bar issue, which applies to penalties as well.
I think I'm only interested in hearing how the time bar issue applies to penalties. You've dealt with it in relation to the end.
This is what I mean. This is what I mean in terms of penalties. Yeah.
You've dealt with it in terms of end of service gratuities, haven't you? There's nothing more you want to say about that.
Yeah, I've dealt with time bar for the first and second contract. This is the time bar argument that applies specifically to the penalties claim, which we say can only arise under the third contract because it's the only contract where you have a potential penalties claim because it didn't exist before then.
Yeah.
And there are really two strands to this. One is to take you through the relevant bits of the procedural history to show you why this is a new claim. And the second part of that is to look at the legal provisions and say this is why you ought to approach it as though it is a new claim, and why a claim for penalties can and repeatedly has been struck out for not being pleaded.
Has it?
It has. Perhaps that's the best place for me to start.
Yes, I required a bit of persuasion on this point, Mr. Doherty, because
I gathered from what you said earlier. So I was...
Well, but particularly in the light of the decision in the Court of Appeal in this very case.
Yeah, so the way I'll tackle the law on this is to go. There are two parts to it. One, there's been an approach which has been repeated in the Small Claims Tribunal when it comes to these pleading points. So that's legal grounds for why one would see a claim being dismissed on the basis that penalties haven't been pleaded. So that's part one. The second part is to look at the industrial group and the Court of Appeal decision in this case, because one needs to do a bit of groundwork to see how those two decisions interact. If I can give you the macro point, TIG effectively deals with the concept of penalties as a substantive right, so a substantive accrued right, and the Court of Appeal decision in this case tells us what happens to claims for substantive accrued rights when applied within the procedural provisions introduced by the 2019 law. So TIG deals with substantive rights. The Court of Appeal judgment in this case deals with questions of procedure and how one proceeds with an action under the 2019 law. I'll come to that second because it's a bit more involved. But just to show you briefly the authorities, which I think should have been added to the tail end of the bundle.
Okay.
So I'm having to refresh mine because I can't actually see it. Yes, so section L, defendant's additional legal authorities.
Yes.
So there are three cases here: Leah and Laredo, Leah and Legacy, Leo and Leona. They are all pretty much drafted in the same terms. So I'm only going to take you to one of them.
Okay.
So if you go to Leah and Laredo, at paragraph 34, the page reference is 1562. And paragraph 34 says the claimant failed to quantify the penalties or add them in the claim form. Therefore, I dismiss the claimant's claim for damages and penalties. And just to place that in context, if one just goes straight to the beginning of the bundle, page 1,
yeah,
which is the claim form.
Yeah.
Robert will, of course, be familiar with both me and Mr. Pratchett-Joyce arguing about the contents of claim forms. But if you go to page 2, we find the description of the dispute. It doesn't refer to penalties. And just above that, at the bottom of page 1, we have the claim value in dirham, just over $1 million, which just
Sorry, which paragraph?
So this is the claim, the stated claim value.
Yes, paragraph.
It's under the heading claim value on the very bottom of page 1. So it's 1,1034979. I'm talking about page 1 of the overall bundle.
I'm sorry, so sorry. I'm not with you at all at present. Should I be looking at page 1558?
No, apologies. I was actually just referring you to the claim form in this case.
Oh, I'm so sorry. Yes, yes, yes.
My apologies. Which is at page 1.
Yes.
So relatively easy to find.
Yes, yes. Okay.
Yeah. And so what I was drawing your attention to is at the bottom of page 1 when it says claim value. It's just over $1 million dirhams.
Yeah.
And you can read it, but we've got the details of claim at the top of page 2, but it doesn't say anything about penalties. The point here really is to say that this is a claim issued in 2019, so 5 years later from the point in time that the claimant would have had to say the penalties have begun to accrue. And just to draw a comparison to the approach that the SET had adopted, he hasn't clearly quantified a claim for penalties, because he's saying that the claim's worth $1 million dirhams, when by this point in time, based on his penalties claim, it would have been worth about $1 million plus. So he's not saying that that's what it's worth this time. Presumably he's not paying the court fee that would have been associated with a larger claim at that time. And he's not set out in the details section of the claim form that this is a claim for penalties. So really that's a way of going about saying that the approach of the SET, when you haven't quantified the claim and when you haven't put it in your claim form, is that that is sufficient grounds to dismiss a penalties claim.
If you work through the documents as you have in your skeleton or elsewhere, the earliest express reference you get to the Article 18.2 is about the 5th of January, isn't it? 2022, something of that kind.
Yes, it's just after the Court of Appeal judgment.
Yeah.
I think I referred to that incorrectly as 2021 in my skeleton, but yes.
Yeah. Let's just look at it in your skeleton. Which paragraph is it in your skeleton? Oh, here we are. That'll be. Yeah. Paragraph 60, 59H, is it? Yes, 59H. Particulars of Claim 5, dated 3rd of January 2022, as it should be.
Yes, June 2022.
Yes. But let's just assume, for the sake of argument, I'm with you on that point, as to the specific pleading. Why does it matter if what's being said is you owe us, you owe a lot of money for pay and due of vacation and EOSG and everything else, and it hasn't been paid? Why does one need to plead specifically and rely on Article 18, which is simply a consequence of law that follows from earlier non-payment?
Yes, well, like I say, the two answers for that. One is, as a matter of practice, certainly that's what the FCT has been doing. But we say that actually, if you look at TIG and the Court of Appeal decision in this case, you also find reasons why under the 2019 law you do have to plead that sort of claim. So I think that's probably a useful point of time at which to go very shortly to the TIG judgment. But I think before we do, a lot of that judgment is about Article 1 of the 2019 law. So I think it is helpful to remind ourselves what that says. So it's at page 1363. If you can just let me know when you've got the page reference.
I've got 1363, yeah.
So Article 1, title and repeal. This employment law repeals and replaces the employment law 2005 to accept or otherwise provide in the law anything done or omitted to be done so that the previous laws deemed to be done or omitted to be done pursuant to this law. Then we've got the saving provision at 3, without limiting the generality of Article 1 and 2. The repeal and replacement under Article 1.1 shall not affect A, any right, remedy, debt, or obligation accrued to or incurred by any person, or any legal proceeding commenced or to be commenced in respect of any such right. So that's has to be read across with A, remedy, debt, or obligation under the previous law. And it says, and any such legal proceeding must be instituted, continued, or enforced, including any penalty, fine, or forfeiture under this law, without prejudice to any right, remedy, debt, or obligation which is accrued or occurred prior to the commencement of this law. And then we've got the extinguishment provision at 1.4, but there's no equivalent provision in this law to provision in the previous law. The relevant provision in the previous law is deemed 5 and repeal and replacement of Article 1.1 until such time necessary for any legal proceeding. The fact that provision in this law reduces or extinguishes rights in the previous law does not prevent it from being an equivalent provision. That's the legislation. Let's look at what is said about that in TIG at 1511. And really, it's the analysis starting at paragraph 53 onwards, starting at the second sentence. Article 1.3 stipulates the repeal and replacement of the 2005 law shall not affect any right remedy accrued or incurred or any legal proceeding commenced to be commenced in respect of any such right under the 2005 law, and any such legal proceedings must be instituted, continued, or enforced, including any penalty under this law, i.e. the new law. And then it refers, of course, to the Court of Appeal decision. In this case, Huffley Bride and the EXPRESSO case is an example of savings provision. So 54, 55, and 56 deal with the party submissions. And in the second sentence of para 54, it says both articles 1.3a and 1.3b make the same point. In shorthand, rights accrued prior to the commencement of the 2019 law are not affected by its coming into force. Article 1.3b does no more than work through the concept in the context of legal proceedings, using accrual as the touchstone rather than the date of commencement of the proceedings. So what it's saying is that if you're reading B, it's the reference to such right that one places an emphasis on, because you have to have a right that refers back to para A. And in 55, on any view in our judgment, Mr. Hammond is entitled to a quantified penalty accumulating by way of daily increments from 22nd of May 2018 until 20th of August 2019. Article 19 for the 2019 law was not enforced over that period, so the fact that a dispute was pending in the court is neither here nor there. Thereafter, on the face of it, the position changed, with the 2019 law now in force. As a result, in a natural reading of the language of Article 19.4a, the penalty ceased to accumulate in terms of the statute, was waived because of the dispute being pending in court. Just to pause briefly on that, so I don't just to save me coming back to it later, that paragraph 56 is binding authority. So even if one was to say or to acknowledge that the claimant had a valid right to penalties, the point in time at which that ceases to accrue is the enforced date of the 2019 law. So from a quantum perspective, we're not looking at accrual continuing until 2023. And that's not the issue I want to deal with now, but I thought I'd just flag it there.
Yep.
The reason I've taken you to that extract is what TIG tells us is that the substantive right under the old law to a penalty can be an accrued right that survives the coming into force of the new employment law regime.
Yes.
So if you have that accrued right to a penalty under the old law, you can still pursue that claim after the coming into force of the new law, provided that it's been commenced before the enforced date, and assuming that you have no limitation issue, because that's the scenario that was played out in the industrial group.
Yes.
So whilst it confirms the existence of the substantive right, the Court of Appeal's decision that in this case, so in the EXPRESSO case, addresses a slightly different question, which is what is now engaged, which is whether there can nevertheless be a procedural defence to the assertion of the substantive right that's confirmed by TIG. So in the decision of the Court of Appeal in this case, the court is directing its thought to the question of how the new limitation period contained in Article 10 of the new employment law, so that's the 6-month limit, interacts with those accrued rights under the old law. And so the relevant extract is page 419.
Yeah. Yeah.
The proposition that Article 10 applies retrospective. So there's paragraph 82, first of all, which is dealing with a case commenced under the old law. So the proposition that Article 10 applies retrospectively, long before the enactment of the new law, has only to be stated to demonstrate the harshness of its operation. So it borders upon arbitrary to the absurd. The question of whether, applying to Article 1.3 of the 2019 Employment Law, read that Article 10 requires such construction, the answer to that question is no. That's not the question in this case. If we continue to paragraph 83, it confirms that Article 1.3 has to be read subject to Article 10. The Chief Justice then asks what aspect of Article 1.3 is subject to that. It can't be 1.3a because that does not, in terms, apply to rights, remedies, debts, or obligations accrued under the 2005 Employment Law. So in other words, if you had the accrued right and you've commenced that, Article 10 can't retrospectively stop you doing it. That's what it's addressed before. It says what the operation of Article 10 then what operation does Article 10 have consistent with the language of Article 1.3? Plainly, Article 10 can operate in respect of that class of legal proceeding referred to in Article 1.3b as any legal proceeding to be commenced in respect of any such right, remedy, debt, or obligation. Article 10 thus imposes a bar against consideration by the court of any claim commenced after the coming into force of the 2019 Employment Law, which is brought more than 6 months after the relevant employee's termination date. Any employee who has not commenced a legal proceeding under the 2005 law within 6 months of termination of his employment would not be able to have that claim considered by a court. The evident purpose of the provision is to pick up employees who may be, as it were, resting on their rights in order to gain a claim for penalties which might accrue against the employer following termination of employment. Now, in that context, I stress the words that specific. So this is in Article 1.3, just below subsection B, which refers to the procedural requirement that any such legal proceeding must be instituted under this law, and the specific words that says including any penalty, fine, or forfeiture. So consistent with the SCT decisions, in order to seek to enforce your accrued right under the old law, the assertion of that right has to be instituted. It has to be a claim that is actually brought. And for that to work, it has to be a claim that is actually pleaded. So putting the provisions of law we've looked at together, just to reframe them in slightly different terms. We have Article 1.3. It's a saving provision, but which saves the substantive accrued right under the old law. And whilst the Article 10 limitation period doesn't apply retrospectively, i.e. before the enforced date of the new law, so that would mean you can have an in-time claim for penalties under the 2005 law if you have started it prior to the 28th of August 2019. So we're not disputing that you can still pursue that claim. That's clear from the industrial group. But what Article 1.3 then says is that where you have the substantive accrued right under the old law, you want to bring an action to enforce that right prospectively, i.e. you're bringing the claim after the enforced date of the 2019 law, then that claim must be instituted under the new law. That's what Article 1.3 says. And so what that means is that if you don't have an action for a penalty under the old law prior to the enforced date of the new law, then your claim is going to be time barred unless you can show that you've brought it within 6 months of the accrual of the cause of action, which in this case is the accrual date that starts pursuant to Article 10. So it's within 6 months of termination.
Where does it say that in Article 1.3? As I read it, without limiting the generality, etc., 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 the repeal and replacement shall not affect rights, remedies, or legal proceedings, and any such legal proceeding must be introduced, continued, or enforced. And then including any penalty, fine or forfeiture under this law, is a reference to the rights, remedies, debts, or obligations accrued, which remain. It's not saying you've got to plead that, is it?
Well, it is saying you've got to plead that, we say, because of the words. So Article 1.3 read together with TIG and the Court of Appeal decision in this case suggests that we're dealing with two issues. One is the saving of the substantive right, that's TIG, and then the second is what happens as a matter of procedure. So even though in this case the analysis might well be that the claimant has his accrued substantive right, the question that arises under the 2019 law is whether we can rely on a procedural bar to that action. And the procedural bar is from the final provision, because it says that the action to enforce must be brought under the previous law, and any such legal proceeding must be instituted, continued, or enforced, including any penalty, fine, or forfeiture under this law. So the point is that
what does the including any penalty, fine, or forfeiture refer to? What's the including bit go back to? What's it qualifying or?
So I think it would be under the previous law, including any penalty, fine, and forfeiture. Right. You could restructure it slightly, so you could say,
yeah,
it shall not affect any action under the previous law, including any penalty, fine, or forfeiture, but any such legal proceeding must be instituted, continued, or enforced under this law without prejudice to the substantive right. That's the way one would read it. But the point is, right, it really deals with the question of automatic application or not of penalties. And so the point that we rely on here is the legislature has decided to expressly include that reference to penalty, and the fact that it must, so that's in mandatory terms, be instituted. So what the statutory provision isn't saying is, well, if you bring a claim for your other accrued rights, your penalties claim will apply just simply as a matter of course and by automatic operation of law. That's not what this provision says. This provision says that if you're going to bring a claim for your accrued right, you have to institute it under this law, under the current law, and that's the law that includes the 6-month limitation period.
I understand all of that, but it seems to me there's a prior anterior question, which is, forget this act for the moment and just go back to the position under the 2012 law. Are you obliged to plead expressly a claim for a penalty or not? Because all this is doing, as I understand it, Article 1, is preserving the prior position, whatever that was. And in order to establish that you need to plead a claim under Article 18, it becomes necessary to say that it was necessary to do so from the moment that such penalties came into existence and were claimable. And my problem is this, that on the face of it, the claim is a claim which follows as a matter of law and statutory entitlement from another set of facts, namely something owing under the employment contract, which isn't paid within 14 days of the termination date. And I can't see why you'd have to plead that at all. And I've seen what is said in the Small Claims Tribunal, but with the greatest of respect to those involved, they don't appear to have any real knowledge or understanding of the purpose of pleadings.
I think the answer to that is contained within the statutory provision itself, because, right, as I say, the distinction here about which law is applicable comes down to whether you're dealing with the question of the substantive right or the procedural aspects of the law. So the question isn't, under the old law, were you entitled automatically to penalties even if you didn't plead it? I haven't set out a submission on that, because in my submission that's not the relevant question, because the moment the 2019 law comes into force, the procedural framework that applies is the procedural framework under the 2019 law. That's, in my submission, the decided authority of the Court of Appeal in this case. And so the question then is, when one looks at the 2019 law, is there a requirement that your claim to enforce an accrued old substantive right, something that needs to be pleaded? And we say that it is, because the words used in the final, so the bit after B of 1.3 says that they have to be, it says they must be instituted, continued, or enforced.
Just bear with me again while I try and grapple with this. It's incredibly badly drafted, isn't it?
And well, I'll leave you with your thought for a moment, but there are just two further points I think I would
sort
of use to emphasize the point. The first is the requirement in the rules, Rule 7.34, which says that all claim forms and counterclaims must state the law to which the claimant maintains governs the dispute. And
I'm so sorry, Mr. Doherty. Give me that again.
7.34a, which requires claim forms and counterclaims to state the law which the claimant maintains governs the dispute, as well as the law which gives rise to jurisdiction.
Hold on. I'm just looking at the rules themselves.
Of course.
734.
Yes.
Oh, well, that is interesting. So B is the jurisdictional position.
Mm-hmm.
So you need to plead jurisdiction under the JAL or whatever.
Mm-hmm.
But the law which the claimant maintains governs the dispute. Leaving aside employment for a moment, that would mean you'd have to say ordinarily the law of obligations, the law of contracts, whatever it may be, and perhaps, well, I don't suppose people would necessarily always put the law of damages in there. But
I think really
what are you saying it means? That you must make express reference to any statute upon which you rely?
Yes, if you're going to plead reliance on an entitlement,
yeah.
So a bit like one might expect in a prayer for relief, you identify the legal basis of that claim. So if it's a claim for breach of contract, you say it's breach of contract pursuant to the relevant provisions of the contract law, etc.
Well, there is, of course, there's a difference, isn't there, here between the DIFC and other common law jurisdictions, because it's essentially a statutory jurisdiction, albeit backed up by common law principles. I mean, if you were to think of trying to do that in the context of a claim for negligence in the UK, the idea that you'd plead Donoghue and Stevenson on a succession of authorities thereafter is laughable.
Mm-hmm.
But is this explicable simply because what's referred to here is a statutory jurisdiction? I'm sorry, I should say a jurisdiction where all causes of action are founded on statute, and therefore you need to plead the statute in question.
Yes, one can easily see the logic and the justification for that. In particular, if one looks at the other comments in TIG about importation of legal concepts and so on, it does make clear that the DIC is a statutory construct created by provision of law, even though it has passing resemblance to the legal system in the UK.
No, I've got all that. I mean, to be frank, I'd simply forgotten, if I ever knew, what 7.34A says.
And what we would also say is that even stepping back for a moment, let's say if one can take the view that there are aspects of 1.3 of that provision that I'm relying upon which are unclear, when one looks at the question of legislative intent, what is this provision what problem is this provision trying to solve? That comes back to what the Chief Justice has already said in this case. The evident purpose of the provision is to pick up employees who may be, as it were, resting on their rights in order to gain the benefit of a claim for penalties which might accrue against the employer following termination of the employment. And so what the 2019 law was trying to do was to draw a line under this historic provision, which was acknowledged by the legislature to give rise to difficult and unjust outcomes, and to include provisions which draw a line under old and stale claims. So what they're effectively saying is, if you've got a claim where the cause of action accrues in 2014, Article 10, if you haven't brought the claim before the coming into force of this new law, then you've missed the boat, because from here on in, Article 10 applies. There's a limitation period of 6 months, and so if you've got a claim that's within 6 months, you can bring it. But if you haven't, then there's in effect a procedural bar or an extinguishment of the right to bring an action for the accrued substantive right. And so that's the effect of Article 1.3. That we would submit is its intention as well, but it's also supported by the reasonably lengthy analysis that's been given over to this issue, both by the Court of Appeal in the Industrial Group and in this case. So ultimately, the question is, are the defendants in this case entitled to look at the way this case has been put, to put forward an assertion that the claim for penalties wasn't made at the outset, and that it was only made after the enforced date of the new law? And if so, does that mean that it's out of time and that can't be saved? And so that's when you come on to my submissions about the relation back principle and so on.
Yeah.
Which I can come to, but in fact, the point is, if you are with me that the claim is only pleaded in any time after the 20th of August 2019, if the penalties claim is only introduced at that point, the effect of that is that the cause of action should be treated as having been commenced on the relevant date, not even that it's pleaded for what it's worth, but on the date that the court, were it minded to do so, accepted the amendment. It's the earliest date, I suppose, could be today, if the court were minded to go down that direction. But ultimately, it doesn't matter, because there is no relation back principle, which means that we're not deprived of our limitation defence anyway. And there's no Section 35 of the Limitation Act to rescue the point here.
Yes, your case on this is essentially at paragraph 59, isn't it? Where you say that in relation to each of the intervening particulars of claim, how many are there?
8 in total.
Right.
Until we get to a pleaded penalties claim, I think it's the first 4 don't have it, and it's only POC 5, which comes after the Court of Appeal judgment, that has what we would say is in any way recognisable as an Article 18.2 claim.
Because the other ones, when they refer to Article 8 or 9 or Schedule 3, always relied on a different section.
Yes,
I'm
happy to take your order there, because what we also say is that it's not just an issue of sort of drafting or making an incorrect reference. If you go through the history of the way it's been pleaded, what you can actually see is that what the claimant has intended to do is to actually rely on a completely different conceptual basis of claim from the outset.
Can we just have a look at one of those provisions, or
Of course.
I want to look at the actual provision rather than the pleading.
Yes, so I'll read you out the relevant bit of the pleading first of all. So this is, I'm talking about the original statement of case now. So it's pages 20 and 21, but it says, breach and contravening provisions law under Article 18, 1964 and 65 of TFC Employment Law for 2005. And then at 21, on the prayer for relief at E and F, what it says is the defendants, we seek the defendant pay interest per Articles 17 and 18 of DIC Law of Damages and Remedies. And F says the defendant acting in contravention be liable for fines and penalties as per Schedule 3 of DIC Employment Law 4 of 2005, amended as Law Number 6 of 2018.
Yeah.
So if we go then to the draft law, which is what this is, if one imagines the claimant's lawyer is sitting down with their law on the left and their laptop on the right as they're typing this out, the provision that they're looking at is at 1359. If you want to let me know when you've got that page, it should be at the top, Schedule 3, Contraventions and Fines.
Yes.
And so what we see there is a list of particular fines that can be imposed, including, if you go to the number bullet point at 17, failing to pay remuneration to an employee within 7 days after the end of the pay period, $2,000. So the penalties provisions he's pleading, they're not Article 18.2 penalties. He's invoking here. In fact, if you go to Article 65, you can see what's actually being invoked by reference to Schedule 3. And Article 65 is specifically referred to in the particulars of claims. So it's 1349. At the top of the page.
Yeah.
So you see it says general contraventions provisions, an employer who does an act or thing, and then it refers to the board of directors as a certificate. So I won't take you through this provision. I'll give you the page reference if you do want to go look at it. But just to give a bit of context about what these provisions were under the old law, if you go back to the 2005 employment law, there's also at Article 79 of that law, equivalent provisions dealing with monetary fines. So for your reference, it's 1214. Those references are then repealed in the 2012 amendments, but have since been reinstated in 2019. I'll come to that in just a moment.
Well, but let's not trouble with any of that. Let's just go on and see where is the first possible reference to an Article 18.2 claim.
If I may, Your Honour, just to, because I think it does really underscore this point, just to go through how this tracks through POCs 2, 3 and 4, it makes it crystal clear what the claimant is at, because you go to 115, which is POC 2, and this is after we've got a defence which says the 2018 law doesn't exist, it's not enacted, there's no provision there that you were referring to. And if you go to 115, POC 2, you'll see this section at F, which is where the penalties claim, which was originally pleaded, has now been crossed out. So this is the first particulars of claim that goes with the claimant's application to amend. So defendant says the applicable law is the 2012 law. Claimant looks at that and says, well, okay, let's look at the relevant provisions of the 2012 law. No, they don't exist, therefore delete. So we would say that that's what's happening here. So the removal of the penalties claim is a reflection of the fact that that regime didn't exist under the 2012 amendments. But when we then go through the subsequent iteration, 129 is the next one. Which is POC 3. We have another go at pleading provisions of law, this time paragraph 21, first of all. We've got an assertion that in default, effectively you owe this compensation interest under Articles 8 and 9 of the Law of Damages and Remedies. But then if you go over the page to the recitals, not to the recitals, to the prayer for relief, what we now get is from POC 2 through to this provision, the penalties claim, or the inverted commas penalties claim, being reinstated, but by reference now to the 2019 law, which still didn't apply, but they're saying Article 68 of DFC Employment Law number 2 2019. So that's said to be the legal basis for the penalties claim. That provision in the 2019 law is at 1391. Article 68, Administration of Fines and Penalties, the Board of Directors of DIFCA may, and it refers to prescribed regulations for specific fine and penalty stipulated in Schedule 2. So we get a resurrection of the same old misconceived DIFCA penalty claim, again under the old law. If you want to look at it, the schedule is at page 1400, but it's you'll understand the format that it's set out in. And even again, if we go to the next iteration of this, 143, we get another stab at it. And just to be clear, paragraph particulars of claim 3 we've just looked at, on our analysis is already out of time because it postdates the enforced date of the 19 employment law, and POC 4 is similarly obviously out of time. But again, it just makes it really clear what the claimant's trying to get at. If you go to page 143, POC 4, if John could let me know when you have that reference.
Yeah, got it.
So here we've got the strikeout. We're replacing Schedule 3 of the 2018 law, but this time we've got it Articles 8 and 9 of the DIFC Employment Law 2019. So again, there's no Article 18.2 claim, but if you go then to these provisions, it's 1364. So right at the bottom of 1364 and the top of 1365. So once again, when we go back to the legislation that claimant is telling us that he is relying on, its administration of the law and the powers of DIFCA to make regulations, to impose fines and penalties. So it's the same old DIFCA penalty claim. It's not Article 18.2.
Yeah.
And so really that's how we then jump forward to the 3rd of January 2022 POC 5. We accept that did put in a reference to Article 18.2. It's the first time that we get that reference. We do take issue with the way that's presented, of course, because by that time, the permissible amendments, we say, were in accordance with what the Court of Appeal orders, and there have been a host of correspondence about this. It leads to the registry issuing a direction saying new claims should be in green and accompanied by an application to amend. Replacement of provisions of law should be in red. And that's, as Your Honour saw yesterday, I brought you to PSE 8, which is the one we've got from a couple of weeks ago, where in recital F, page 352, the reference to Article 18.2 is written in green. The green text indicating that claim solicitors know that this is a new claim beyond what it had previously sought permission for.
Yes.
So what that leaves us, we say, is there's no Article 18.2 claim pleaded. It doesn't appear anywhere until January 2022. Even then, the only form that complies with the registry's order appears just a couple of weeks before trial, so in April 23. It isn't accompanied by an application to amend. There is no such application before you. And I'm happy to address, Your Honour, and what we say about what an application to amend would look like, what the relevant considerations for the court are, whether the court can actually even entertain it, and so on. It depends if you feel you need me to address you on those, or if you're with me that the relation back principle can't apply in the DIFC and that's the end of it, if I'm right up to that point.
I'm still struggling with this point, Mr. Doherty, for this reason, that plainly the requirement in the rules is a procedural requirement to plead the law upon which you rely. And so I'm not quite sure that I suppose the bottom line question is really, is this a different cause of action? You know, the Court of Appeal focused on the facts which give rise to, I mean, a cause of action is a set of facts which gives rise to a claim. That's how a cause of action is described in Latang and Cooper and a whole bunch of cases since. And so the question that I really have in this context is, are we really talking about something to which the statute itself applies when you're talking about an Article 18.2 claim in isolation? I mean, obviously, if you're talking about the facts which give rise to an Article 18.2 claim, those have to be pleaded. And if you try and plead a new cause of action that's time barred, the court says, no, you can't do that because it's got no realistic prospects of success. But I'm still struggling as to quite what the impact of Rule 7.34 is on any relevant cause of action in the light of what the Court of Appeal says. And we're specifically, aren't we? We're looking at paragraph 88. paragraph 88 in the Court of Appeal, it's clear initially the appellant was asserting a cause of action for breaches of or arising out of 2005 employment law. It's the asserted facts that define his cause of action rather than the particular law which he invokes. He should therefore have leave to amend his particulars to invoke such provisions of the 2005 employment law as support the relief which he claims by reference to the facts which he's alleged. And when I read that, that accorded simply with my immediate predisposition, which is that you don't actually have to plead the law. Well, of course, as you rightly point out, Rule 7.34 says you should plead the law upon which you rely. But if you're looking at facts that constitute the cause of action, it's all there. And what the Court of Appeal is saying, well, he must have leave to amend his particulars to get the law right.
Yes, although I suppose it depends how widely or how narrowly one can read that, because what we would say is that the Court of Appeal is effectively giving him leave to go and correct and replace wrong references to the 2018 law with the equivalent provisions. So that, I think, then leads to the question is, well, as you were saying, are we really talking about a new claim here? Well, from a legal standpoint, yes, because the only thing that's been asserted up to that point in time is a right to DIFCA penalties. It's clear in my submission from the Court of Appeal's judgment in the industrial group that a penalties claim has to be considered its own freestanding cause of action, because the whole analysis that we did in that case is about establishing what is an accrued right.
Yeah,
what is a substantive accrued right. And so it is clearly a substantive accrued right which stands as being different to what the other rights might be. And so, for example, if one is looking at what is the idea of a right, so for example, your right to be paid, that is a substantive right which can arise in two ways. In this case, it can arise as a matter of contract under the employment contract, but it can also arise by operation of law. Strictly, they're both by operation of law because of the DIT's framework, but you take my point. Similarly, your right to notice, you've got two potential sources for that sort of a right. You could say that I'm contractually entitled to 6 months notice, or I'm entitled under the employment law to my 3 months notice. But I think you could perfectly validly say that if someone is coming to you with a claim for a contractual notice, and you say to them, your claim is out of time under the DIT contract law. Oh, well, sorry, put it the other way. Let's say you're working in 2019 confines. You're asserting a statutory right to notice pay under the 2019 law. You're looking at that law applying a 6 month notice period. But that's not to say that you couldn't come before the court and argue, even if you're out of time for 6 months, that you've got a contractual right where you've got a 6 year notice period. So it does make a difference what not only the factual circumstances behind your claim are, but also the precise legal basis on which you're presenting the claim, because it has an effect on the defences that one standing in the position of the defendant can rely upon. So if the core question is right to a penalty something which is a new claim which needs to be pleaded, we say that the answer to that is yes, for a couple of reasons. One, because it's consistent with the analysis of the Court of Appeal in both cases, but also because we've got the underpin in the rules, which requires you to refer to the provisions of law. And we've also got the statutory footing in the employment law, which requires you to, I don't know the language in front of me, is it initiate or commence, instigate or commence your claim in respect of your accrued right to penalties. So we have multiple sources saying you have to plead it. If you add to that what appears to be the practice of the Small Claims Tribunal, which is you haven't put it in your claim form and you haven't quantified it, so I'm not going to give it to you. We say that that does have the effect of putting us in a position where we have to look at when this claim was introduced, or even if it has been introduced. And if it's after the 20th of August 2019, The question is there any way, as a matter of DIFC law, that the claimant can salvage the position? And we say that there's not, because there's no Section 35 of the Limitation Act, even if you were to make an amendment or to allow an out-of-time amendment.
Yeah, all right.
As I say, I'm happy to address you on those couple of points on relation back, if you wish.
No,
sounds as
I
though
don't.
perhaps you don't wish to. Can I just to round that particular submission off? Can I raise a couple of short points on abusive process? Your Honour, I think, has heard from both myself and Mr. Pratchett-Joyce on this issue relatively recently. The reason we don't go down that route is because, for obvious reasons, to strike out a claim as an abusive process, you have to have a pleaded claim in the first place, and that's not the analysis that we get to. It's not to say that it wouldn't be within the court's discretion to do that if you were to form the view that this was an abuse. And that's a two-stage test, which, again, has been discussed before the court relatively recently, but is the claimant's conduct an abusive process? And if so, it's a question of discretion. There's no finer point on it than that. The relevant, I suppose, facts to the exercise of that sort of discretion would be similar to what I've said about the exercise of a discretion to allow an out-of-time amendment, which is the conduct by the claimant of the proceedings, the delay that's been involved, and so on. And John, I'm not going to labour on this point. We do take issue with what my learned friend has said about the delay in these proceedings. The Court of Appeal couldn't have been more clear about who bore the responsibility for the state of affairs in its allowing the costs order made below and in describing the claimant as the author of his own misfortune. Again, I'm not going to labour over that point, but the defendant rejects any suggestion that it's culpable for the delay in these proceedings. It was perfectly entitled to take points that it did in respect to the pleadings, and in fact, that's what leads us to the position that we're now putting before the court, which is that there is a procedural bar to this claim, which arises as a consequence of the procedural history of this case. Your Honour, I said I'd do a few bits of sweeping up. The notice claims under the third contract, I think I've heard from what you have said in terms of the contractual provisions. The only gloss I think I needed to add to that really was to say that when one looks at the legislative provisions that applied at the time, specifically Article 59.3, it's page 1296, but it makes it clear that it is open to an employer and employee to agree longer or shorter periods of notice than those prescribed by the statutory provisions. So in the case of a fixed term contract, the analysis is if you're on a fixed term contract, which by operation of that law comes to an end on the date it says, you must be taken to have contractually agreed that you weren't going to have an entitlement to statutory notice. And that's even before you put the factual issues with this aspect of the claims claim to one side, including the January 2014 email and so on. Unless you want me to, I don't propose to.
No, thank you.
Trouble you with that. On the various entitlements, annual leave, air tickets, we say that they're use it or lose it entitlements. I think you probably have.
I've got the argument
there. And I can take you back to what we said about quantum earlier, but I think, or I take it you had my point that if you've got a continuous contract when it comes to your annual leave accrual, by the time you get to year 5 or year 6, the only potential payment in leave you would get is in respect of the last year.
Yes. Because
at each successive year, the entitlement has disappeared. You, I think, have my point on the penalties claim and the effect of the industrial group and when that claim would be deemed to stop accruing on the 28th of August.
Yes.
And I wanted to just add to my points on quantum. We don't accept the calculation of the daily wage on the basis of there being 250 working days. the reason for that is that, first of all, the habitual practice of the court is to use 260 days, which is simply you take 5/7 of the number of days in a year, and that gives you 260. The way that my learned friend gets to his calculation is to say, well, I've gone to this particular year and I've looked at which days were public holidays. That slightly misses the point, because the provisions of the employment law, specifically Article 32, operate to treat public holidays as though they're the same as working days. So you're allowed to take the day off, but you get paid for them. So it doesn't make sense to take them away when you're trying to calculate the number of working days in a year and therefore work out the number of days that one should be compensated for. So the correct number is 260. If you plug that in, the daily wage would come to 646.15, not 672.
Yeah.
Your Honour, you'll also seen that we refer to, it's effectively a construction argument under the 2012 law about how daily wage ought to interact with penalties. So the purpose of the daily wage calculation is effectively to try and work out what your entitlement should be if you take a day's sick leave during a working day, and what you should be compensated for that. And so if one goes to provisions on things like sick leave, I think maternity days, I think there are others, the reference that's made there is that you get payment of your daily wage for each particular working day that you're sick. What we say is that the proper construction of how that should apply in a penalties context shouldn't be that you get paid more than you would if you were just working as normal, because here the slightly so it's artificial process. What we're doing is working out what you get paid over the course of 260 days and dividing that evenly across, and then multiplying it by 365, which means that in a penalties claim, you're going to end up on an annual basis getting more than if you just stayed in employment altogether. And we say that the legislative provisions don't intend that. What they would have intended is that, in effect, you're in no worse a position than you would have been if you'd stayed in employment. So that the best way to construe your entitlements to a daily wage is that you're entitled to a daily wage for each working day prior to payment. So that would be a matter of taking the number of days that the learned friend submits are relevant, and it would be 5/7 of that. And Your Honour, the final point is on an airfare. We say even when you just get a quantum, it's a grossly deficient claim. There's no quantum evidence before you at all. There's no evidence of who would have been taking the flights. It's not a claim that can come up to proof, and is not one which can be quantified by the court, and so should be dismissed on those grounds. Let me just check with my instructing solicitors whether there's anything else that they want me to raise, but I think that might be that. Yeah, thank you, Your Honour.
Thank you very much, Mr. Doherty. Yes, Mr. Patrick-Joyce.
Your Honour, I'm obliged, and I appreciate the time. I will be as quick as I can be. I had anticipated on the learned friend's time estimate that he would have finished at about 2:15, and that would have given me much more room and much more time. I will not waste time. Your Honour, let me deal with the last substantive point, which was the pleadings point. Would I ask Your Honour to go to page 13 in the bundle? Page 13, Your Honour, is in the middle of the original particulars of claim, and by coincidence, paragraph 13 is on that page. And if Your Honour goes down to about 6 or 7 lines above the foot of that page, Your Honour will see that under this paragraph on cause of action is expressly pleaded, amongst other matters, along with penalty for non-payment of the claimant's dues as accrued since 2014. That is a factual claim for the statutory penalties under the substance of the Act, which is separate and distinct from the Schedule 3 fines, contraventions and penalties. If I then ask the court to go on to page 20, there is an express reference in paragraph 17 to the claim being brought on the basis of in default of articles 18, 19 and other articles of the 2005 law. Article 18 principally, but also Article 19 deals with exactly what we are talking about, payment where the employment is terminated. Article 18 is again repeated at A1 in the prayer. And at each stage, if Your Honour goes through the page references that my learned friend gave, and goes back to look usually at paragraph 13, but in some instances it's been renumbered to paragraph 14, like a golden thread running through each and every incarnation of the particulars of claim is the claim that we have seen pleaded as a matter of fact and law under cause of action and carried through to the succeeding paragraphs that I have taken Your Honour to. The only reason why Article 18.2 is in green in the amended particulars of claim of the 17th of April is because, consistent with the express requirement of this court's order, we were setting out and making express that which has always been implicit. It was purely clarificatory, and the green was because of a change of wording. It was not a change of substance. In short, my learned friend's point on this is in our submission completely unsustainable and thoroughly bad. I also take Your Honour's point about whether the difference of cause of action and the pleading of sets of facts, but in my submission, it's absolutely clear that there is nothing in my learned friend's pleading point. Other points, and accepting that there's a general joinder of issues, so I'll simply deal with specific points rather than an overall review. On acknowledgement of debts, I do urge the court to look at how we put it in the skeleton argument. In particular, this is not a Section 29 of Limitation Act 1980 point. It arises from the words of Article 38 of the DIFC court law, which we've set out in extenso in the skeleton argument, plus the cases that I have cited there, and in my submission that establishes the case for the claimant on the basis of acknowledgement of debts. My learned friend then spoke about the need for renewal, quotes, under the same contract. so far as that is concerned, it was a very small point. It was a point which seemingly led nowhere. The clause 14.4 point, you'll recall it, Your Honour. It was a nonsense. It's a nonsense in the 2008 agreement. It's a nonsense carried over into the 2010 agreement. And it's a nonsense carried over into the 2012 agreement. Anything more emblematic of being under the same contract, it's difficult to comprehend. Of course, there were changes in relation to the man's title, job title. He was promoted. Of course, there were changes in relation to his salary. Inflation and reflection of responsibility takes its course. And of course, he changed his marital status, so other matters would adapt as well. The next matter relates to my learned friend's submissions in relation to Article 4. And if he were right, then in essence, his case seems to amount to a submission, well, the law applies to you because clause 19 says this contract will be governed by the DIFC law. But then when we look at the law, Article 4 says it doesn't apply to you. So it's simply a revolving door, which is an extraordinary state of affairs if it were to be the case. Of course, it isn't the case because the legal basis chosen, or the legal base chosen by the employer, chosen by EXPRESSO, is an absolute answer to the point. And if one looks at these agreements, they are redolent and replete with references to the DIFC employment law. Clause 12.3 on page 797. Clause 12.1, page 895. Clauses 6.1, 7.2, 9.5 on page 891 and following. This entire contract was based and premised on the application of the DIFC employment law. My learned friend referred to Serco. In my submission, the court won't gain much assistance from that and cases referred to in it, so I'll leave that to one side. With regard to the relevance of the Sudan proceedings, and I think Your Lordship, Your Honour gave the example of holiday entitlement. If you aggregate the holidays, it's 35 plus 24, it comes to 59. Of course, if you put the boot on the other foot and you say, oh, well, holiday entitlement can't apply here, it must apply there, then by doing that, you end up with no holiday entitlement. And in my submission, the way in which you answer that, or the court should answer that, is to bear in mind that this court is concerned only with this jurisdiction, and that is the proper basis and touchstone for proceeding. On the authorities that my learned friend has introduced just during the course of closing on the SCT, Small Claims Tribunal cases at the end of last year, the beginning of this year. First of all, Small Claims Tribunal cases are not binding. Secondly, I respectfully adopt what's already been said in relation to what should properly be pleaded and the role of the applicable law in that regard. I'll come back to that very briefly subsequently. We've already looked at paragraph 13 on page 13 of the original particulars of claim and indeed matched that up, construing the document as a whole with the subsequent paragraphs, where fact, principle of law, and reference to law relied upon was all clearly set out. And of course, standing back, one cannot really quantify penalties. You may be able to do it on a daily rate, which is what we've done, and it's the way in which conventionally interest calculations are done as well. But technically, you can't quantify penalty because the right is continuing to accrue on a daily basis. On Miller & Friend's point about his construction of Article 1.3 of the 2019 law, I have to confess that I didn't understand Miller & Friend's argument when I read it, which in large part was why I had reserved the right to come back when I heard it developed orally. And in my submission, I now understand better what he is saying, but with all respect, it is simply an unrealistic approach for the reasons that have already been parsed and analysed by the court in relation by asking what do the words or the phrase prefaced by the words include or introduced by the words including any penalty mean and what do they apply to? And in my submission, Miller & Friend's analysis is unrealistic and far too cute. It's technical and really goes nowhere in my submission in the real world. The next point is arising from these are all similar approaches to the same point. The rules of the court and rule 7.34a, the needing to plead and state the law. Well, for the reasons I've already taken you to, Your Honour, in page 13 and subsequently following the golden thread through the pleadings, we fulfilled and complied with that requirement. And it can't possibly be, in any event, an exhaustive requirement. Once one has signalled what one is doing and relying upon, then that must suffice. And in my submission, we have amply satisfied that requirement. Your Honour, I'm pleased to say that it is exactly 3 o'clock, which is exactly 6 o'clock in Dubai. I could detain the court by 2 or 3 more minutes by asking for time to check with those instructing me, but perhaps Your Honour will appreciate it if I don't waste time, and I'm sure the court staff will be equally appreciative given that it's 6 o'clock for them. But Your Honour, unless
If you feel you need to take instructions, I'm sure we'll bear with you for 3 minutes.
I will very quickly in that case, because for form's sake, if for no other, I should do so. I'll switch my microphone off and camera. I'm obliged, Your Honour. Your Honour, I don't even need 3 minutes. I've been able to review comments which have been forwarded to me during the course of proceedings, and I've confirmed with those instructing me that everything that we wish to place before the court is placed before the court. I'm very much obliged, Your Honour.
Very good. Thank you very much indeed, and thank you for sticking to the timetable for the court's perspective. I don't think there's any right of reply, Mr. Doherty, on any new points of law. So unless anybody has anything to add, that concludes the proceedings, and I shall reserve judgment and hope to have you let you have something as soon as I can apply my mind and put pen to paper. Anything else that needs to be said at this stage?
No, Your Honour, save thanks to the court for sitting late.
It's the same from my perspective, Honour.
I'm sorry, Mr. Doherty, I didn't hear that.
It's the same from my perspective, Your Honour, nothing to add, and thanks to the transcribers and the court staff.
Indeed, my thanks too for everybody staying late, and thank you both very much. And you'll hear from us in due course. If you wouldn't mind signing out, I'll have a very quick word with the associate.